Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Gildea and McCabes. Ridiculous that insanus. Oy vey, Marcus. Pro said, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Hump Day, cupcakes. Happy Hump Day. Shout out to Microdots today. Wearing the Microdots hat. Takes an army. Takes an army to root out all the corruption. It takes an army. Am I right? Or am I right? Thank you, Shelby Ray. Happy Hump Day to you too. It's beautiful in New Hampshire today. It's beautiful in New York today. It's beautiful, I think, all over the East Coast maybe today. It is a gorgeous, gorgeous Wednesday today. Today's Wednesday, July 8th, 2026. And I mean, can we get out of Massachusetts? Can we get out of Massachusetts? I don't think so. Yesterday, I just had to take a break. I had to take a break. It's like enough with the drama, everything, things dropping all over the place. It was crazy. It's crazy. And so I saved it for today. And so we're here today. But there's more. But wait, there's more because there's always more. There's always more. And if any of you are coming in on the replay, hit the like button on your way in. And if you're here watching right now, hit the like button now. I promise nobody's going to get your DNA. And even if they did in Massachusetts, they wouldn't know what to do with it. They wouldn't know what to do with it. It's cold in Oz. Wow. That's interesting. How cold is it, Black Widow? Cupcakes with icing. Yeah, it's crazy. I mean, all I could say is you guys were right. You guys were right. You guys were right about the tweet that the judge was referring to. But here's the thing. We saw the decision on the motion before we ever saw the motion. And so I said, let's wait. Let's wait until we have the papers. We got to wait until we have the papers because we really don't know what the judge is talking about. But you guys were right. Because you guys, nobody's smarter than you guys. You're the smartest chat on the internet. And you know you are. But before we get there, let's look at our motivational quote of the day, shall we? There's two, actually, because we were not live yesterday. So we'll do yesterday's and today's. Yesterday, Thomas Watson said, nothing so conclusively proves a man's ability to lead others as what he does from day to day to lead himself. Or herself, I will add. It's 0 degrees Celsius today. 0 degrees Celsius today in Australia. Thanks, Carrie Smith. Once again, Thomas J. Watson said, nothing so conclusively proves a man or woman's ability to lead others as what he does from day to day to lead himself. That's right. Lead by example. Lead by example, my friends. Thomas J. Watson said it a long time ago. I like to quote my sources when I read you motivational quotes, unlike some people, even from the bench. Today's motivational quote of the day for Wednesday, July 8th, 2026 is a quote from Farrah Gray, who said, oh, that's a good one. Build your own dreams or someone else will hire you to build theirs. How great is that? Build your own dreams, or someone else will hire you to build theirs. You're never too old to dream a new dream. I don't know. It's not gonna fuck us. Fuck us. All right. Let's pull a card from the affirmations for a badass deck. We need that too. We need an affirmation. Here we go. We'll shuffle the deck. Fairy tales can come true. It can happen to you. Okay, ready? I like this one. I like this one. When life knocks you down, get back up and say, you hit like a biatch. When life knocks you down, get back up and say, you hit like a bitch. There it is. To all my nurses today who are on strike outside Brigham and Women's Hospital, we see you. We see you. I assume it's still happening. I saw some news pieces earlier this morning for all the nurses who are out there striking. And listen, nurses, I tell you this every stream practically. Talk about nurses all the time. Have a lot of nurses that are viewers, and you're the angels. You're the angels of the hospital. You really are. The doctors take all the credit. The nurses do all the work. And really, your hospital stay depends on the quality and the compassion of your nurses. You know it. I know it. Hospice nurses, NICU nurses, all nurses. We stand with you, nurses. We stand with you. Microdots. Michelle, thank you for your super sticker and also for your Cash App that you sent before the show even started. And Proctor got Waffle, thank you for your 5 memberships. I appreciate you so much. Yeah, give the nurses everything they want, and then some. Georgia Cat Mom became a member because she knows what's up. And Charissa is here. She gifted 5 memberships too because she's also amazing. Also amazing. Debbie says there was a smarmy anti-Karen Reed article in the Boston Globe today. Disappointing when it comes from another woman. The kicker, the author got Officer John O'Keefe's age wrong. Well, I didn't see that, but I do have access to the Globe, so we'll put that on the docket for the day because I got a full docket here. Globe article. That's why people don't watch mainstream media anymore or read mainstream media anymore. This is why so many people get their news from YouTube because it's unfiltered, uncensored, and we're not going to lie to you. Thank you, Debbie. Julie Jensen, thanks for your 20. Mel, the headdress on the back of your chair makes you look like you have angel wings. I know. It is the chair. Perfectly fitting for you. She's like, can't unsee it. You're an angel for all you do. Oh, I got a new chair. Took me a really long time to put it together, but it's worth it. It's comfortable, except it doesn't have me upright enough. So I feel like I have to like lean over. I gotta fiddle with the controls, but it's funny. That's funny and cute. Thanks, Jill, for your 20. Super on top. You're always on top of the super sticker, and I love you so much. Holly and Johnny is celebrating her daughter Kiki's 35th birthday. Happy birthday, Kiki. Ready to hear all the shenanigans going on with me, the Queen Melanie. Love you with all my heart. Thank you for all you do. Oh, you're welcome. You're welcome. I love you guys so much. I really do. I love you so much. Well, what had happened was today's July 8th. The emergency motion to clarify the record was made by Karen Reed's attorneys on July 1. There was a supplement to that didn't hit the docket until July 2. There's a lot of misinformation out there about Karen Reed's attorneys making 2 different emergency motions to clarify the record. That's not true. It's not true. It's not 2 motions. It's 1 motion with a supplemental memo of law. Okay. So don't be fooled by what you read on the internet. To recap, on July 1st, Wednesday, July 1st, that was the day. It was a Wednesday. Wait, I got to look at my calendar. That was the day that Judge Gildea held his emergency hearing and he brought in all the attorneys. This is in the O'Keefe versus Karen Reed in the Waterfall case. It's the wrongful death case. You know, the car accident, wrongful death case for the car accident that didn't happen. July 1st. he ordered every single attorney who had made an appearance in this case to come to court the Wednesday before the July 4th holiday weekend. And when they got there, he read a soliloquy, stood up, walked off the bench, didn't let any of the attorneys be heard. I think Bob Motta, I'm going to give him credit for this. He said, that wasn't a hearing, that was a listening, because nobody was allowed to address him. And he made some allegations that somebody sent him a tweet, and that tweet led him to believe that there was a leakage. That there was a leakage of Michael Proctor's personal information that was contained within the affidavits filed by his counsel on the afternoon of June 8th. June 8th was the all-day hearing. Remember the all-day hearing? It wasn't really all day, but there was a hearing in the morning. It was supposed to be Proctor's deposition day. And a couple days before, Proctor's attorney came in and moved for a protective order. He didn't want Proctor to have to testify. Proctor didn't want to have to testify. And he had some kind of very generic information in there about why he couldn't testify. He said, he's got family issues and medical issues and he just can't possibly make it. So this emergency, because Karen Reed's team was like, hell no, we've already arranged everything for his deposition on Monday. We're not going to reschedule it. So they made an emergency motion for a protective order. And the judge called them into Zoom on June 8th. It seems like Proctor's attorneys filed the papers on the Sunday, June 7th. The hearing was on June 8th. And the judge said, listen, I don't what you gave me isn't enough. I'm going to give you until 4 p.m. today, Proctor's attorney, to give me some additional information about why he can't possibly make it. And I'll make my ruling at 4:15, right? 4:15 came. He made his motion. He said, I'm not buying what you're selling, Proctor's attorney. So Proctor's going to have to come in tomorrow for a deposition. And then Reed's attorneys were like, no, we can't make it tomorrow. And I was screaming. Just I had a feeling that some shenanigans were going to happen. And if they didn't do it right then or start it right then, something else was going to happen. And by all means, it did. Because on June 25th, Proctor did show up for his deposition. But it didn't start until 12:30 because he asked for it to start at 12:30. And it ended at 5 o'clock because he needed it to end at 5 o'clock. And then the very next day, on the 26th, is when the judge became aware of this mystery tweet. But what was so weird about it is that the tweet went all the way back to June 8th, which would have been the day that the hearing happened and the day that those papers were filed. The judge has already told us that he read media. He read something in the media about Karen Reed's Today Show appearance. And so we're racking our brains. Where did he get this from? Who gave it to him? Was it a troll? Did somebody change the timestamp? So you guys were all over it. You're Aidan tweeted at 10:52 in the morning, which would have made, if somebody didn't, looked at it from an incognito browser or from somewhere else in the world, it would have shown up as UTC time, which would have made it 2:52. And the papers were filed at 2:22. And the judge said it was exactly half an hour later. That Michael Proctor's private information that was contained within the affidavits was all over the internet. And I said, I really don't think it's that. I really don't think it's that, because the judge said that the person's not a party to this case. Right? And where did he get it from? And we're are crazy people emailing him? We've seen a lot of Michael Marcy's emails lately. That happened in November of 2024. Somebody emailed him about me, a crazy person in all caps, suggesting that me and the Glairer and LTL should all be charged with RICO for being on YouTube. And what did Michael Marcy do with that email? He forwarded it to Tully and Brennan. So we're thinking, what could it have been? Who sent it? And I said, well, we haven't seen the papers, so we don't know. Let's hold. Because then that crazy order came out, Judge Gildea's order, which we're going to look at again, because he wouldn't let anybody be heard. So we had no idea what he was talking about. We didn't even know if the attorneys knew what he was talking about. But the attorneys did know what he was talking about because right after that hearing ended, Karen Reed's team filed a motion to clarify the record, an emergency motion to clarify the record. And we're going to look at that first. Hopefully that summary. I don't know why I just went off the screen, but I'm back. So never fear. I'm always here. Maybe we're breaking YouTube, but I don't think so because I know that Emily was talking about this too. And she had like 14,000 people over there, which I didn't realize, but it is what it is. I don't look at anybody else's schedule. Here we are. We're going to do it. So this is the emergency motion to clarify the record, which was filed the same day as that crazy hearing, July 1st, 2026. And I said to you, I said, I bet you Liza Little is furiously typing right now on her laptop because she's on Zoom and she's on top of everything. And I bet you she's furiously typing. And of course she was. All right. So this is the emergency motion to clarify the record. Because remember, the judge said in another hearing that I'm going to play for you because I got little clips pulled up because I want to put this all together for you in one place. The judge had said in an earlier hearing, listen, you can make a motion to clarify anytime if you don't understand what I'm talking about. Make a motion to clarify. I'm not gonna let you clarify it on the Zoom hearing. Remember? It's crazy. All right. So here's the emergency motion to clarify the record. Filed the day after that crazy hearing. Today, the court stated on the record that an attorney with an appearance in this case had violated either the letter or the spirit of the rule. That statement and those that followed were based on an incorrect premise. Namely, the information that the court claimed had been disclosed by an attorney was already public as of June 6, 2026, at the latest, more than 2 days before the filing or impoundment of the order at issue. More than 2 days before the filing or impoundment order at issue. Thus, the entire foundation upon which the court called today's hearing and admonished counsel was factually flawed. Now remember, this was filed after the judge left the bench. And so I don't know if the judge knew that it wasn't right when he made this crazy ruling, but we're going to use our context clues and our spidey senses to try and figure. On June 6th, the ex-user the court referred to today held a live stream on YouTube during which he stated that he had received the same information from a third party. That was 2 days before the impounded filing the court believes was improperly shared. That YouTube clip is contained on the USB drive attached as Exhibit 1, and we know that that is Turtle Boy. Turtle Boy got a source. I'm gonna play the little clip of that for you too, because we're not doing anything half-assed here. We're gonna do it all. Lawyers get reimbursed for travel. They get an hourly rate. Travel time is billed at the hourly rate. Goes on to say, so they gave the judge a USB drive with Aidan Kearney's YouTube presentation or a clip of his YouTube presentation from 2 days before the filing. And then it says here, the following posts that also predate the June 8th impounded filing also show that the information in question was public prior to that filing. And here's some tweets. On 6/6/26, they've got screenshots of tweets. KY Maverick tweeted on 6/6/26, asked the Proctor's deposition, which do you believe will most likely happen Monday? Poll ends before Monday hearing. So this was 6/6 was Saturday. Judge grants the motion. 25% out of 322 votes says the judge grants the motion. Denied and deposition, 51%. Denied and no deposition, 24%. And then Shari Thompson tweeted, TB, Turtle Boy was live. The source, though not vetted, stated that Proctor had been at McLean and transferred to a mental health facility in Florida. If that's true, did he have a nervous breakdown knowing AJ was deposing him? Are the McAlberts concerned he's a weak link? And you can say 6/6/26 from Lancaster, Pennsylvania. And you can see also KY Maverick's tweet had 3,700 views and Shari's had 206 views at the time that this was printed. Again, this is the Afro Man effect. When you want to attract more attention to something, go crazy about it. Because now the internet is interneting. Okay. The armchair detectives are doing the work. They're watching in Yorkshire, in the UK. The UK is watching. Amanda's here from the UK. And 6/7/26, which would have been at 7:24 p.m., Petty Boop 617 says, I'm sorry, but if Proctor's in a hospital in Florida, did they not know this before the close of business on Friday? Again, before the impounded stuff was filed, and that only had 89 views. No shade to Petty Boop 617, but it's not like there's tens of thousands of views on this, right? Okay. They go on to say the court departed the bench immediately after making these statements without permitting any counsel to respond. Defending Karen Reed's counsel immediately asked to be heard to inform the court of these important facts that would correct the record, but the court refused to allow comment and refused to retake the bench when asked. Yeah, he was like, no, I don't want to hear it. XOXO, Damon Seligson. Okay. So they served that the same day as that hearing by email on all the parties. But wait, and there's more, because then they had more information and they wanted to supplement. And this was filed on the next day, July 2nd. So now they're saying, okay, here's some more information, because obviously they were doing this on the fly. So this was filed on July 2nd. Defending Karen Reed's supplemental memorandum of law in support of emergency motion to clarify the record. Do you see this is not a, do you see why this is not a separate motion? This is a memo of law to support the motion made the day before. After the court's emergency hearing on July 1, 2026, and after filing her emergency motion to clarify the record that same day, defendant Karen Reed became aware that the ex post that the court cited as the only evidence that its impoundment order had been violated was actually posted before the relevant June 8th, 2026 filing by third party Michael Proctor. The court stated at the hearing that Proctor's counsel sent the relevant pleading and exhibits to the court and counsel at 2:22 p.m. on June 8th, right? We knew that. He said that. And that the ex post in question was created exactly 30 minutes after the email to counsel. And he said that too. You remember, I know you do, because we watched that hearing, I don't know, 14 times, I think. And contained information similar to the information contained in Proctor's filing. That is incorrect. Well, they're right. As the court can see below, the ex post in question, which was provided to the court by Proctor's counsel. Okay, so there it is. The ex post in question, which was provided to the court by Proctor's counsel. Proctor's attorney, Mr. Hamill, is the one who sent the ex post to the court. How did he do it? Did he send it by email? Because it's not part of the court record. Did he send it ex parte to the judge? That's improper. Did he send it to everybody? How did Karen's attorneys know? How did Alan Jackson and the team know that that was the tweet? Well, they must have showed it to them prior to the hearing. Or they found out afterwards, because they did all look kind of dumbfounded, like, what are you even talking about? But here it is, right here. I'm going to even make it pink. The ex post in question, which was provided to the court by Proctor's counsel. When was it provided to Proctor's counsel? I mean, when did Proctor's counsel provide it to the court? Was it like the day that he ordered the hearing? I have so many questions. And if Proctor's counsel knew about it all the way back on June 8th, why didn't he report it then? Why did he wait until something like, I forget the day that the judge ordered this. I think it was maybe the 26th. It was, or maybe the 29th. Maybe it was 2 days before. They had to be there within 48 hours, right? So it had to have been the 29th, which was a Monday. When did Proctor's attorney send Aidan's tweet from June 6th to the court? 3 weeks later? Do you really think there's not an army of people out there who really, really, really want to get Aidan Kearney in trouble that didn't send that to Michael Proctor's attorney far before June 26th? Is anybody, June 29th? Is anybody buying that? Or did he send it the day after Proctor's deposition, which would have been the 26th? They did have a status hearing that day. The timing is suspicious. It's interesting. But Proctor's counsel, we know, I think his name is Matthew Hamill, Mr. Hamill, I'm just going to call him Mr. Hamill. He's on East Coast time, right? So if he was to look at Aidan Kearney's tweet on his own, it would have showed up as 10:52 a.m., not 2:52 p.m. Who sent it to him? The image provided by Proctor's counsel had a 2:52 p.m. timestamp. Okay, so not only did Proctor's attorney submit it to the court, he also submitted a screenshot of it, but the screenshot that he provided had the 2:52 p.m. timestamp. You see what's happening here? However, that is because it was apparently accessed by a user without an X account, which defaults the time zone to Coordinated Universal Time, UTC. Or it could have been somebody, right, with a, what if you do it in an incognito browser? I don't know, but I'm not a forensics expert. But Aussie Insider did a whole video on this, and I was like, yeah, I don't know yet. Let's wait and see. Let's wait and see if this is really the post. Maybe it was something else, but this is really the post. Because this is the post provided by Proctor's attorney to the court. So UTC time is 4 hours ahead of Eastern time. When accessed by a user with an account set to Eastern time, the post appears as follows. And if you look at the bottom, it says 10:52 a.m., June 8th, 2026. Aidan Kearney, Dr. Turtleboy tweeted, Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Karen Reed's lawyer made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue with based on her comments on the Today Show. He stayed the depo for 24 hours, and at 4:15, a hearing will be held. Okay, so this was before any of these papers were filed, because we know the files were the impounded documents with the private letter or affidavit from whatever provider submitted it wasn't filed until 2:22 p.m. Aidan goes on to say, my guess is he's going to tell Proctor to jump on a plane and stop being such a P so Alan can depose him tomorrow. And his guess turned out to be right. The papers go on to say the message was actually posted more than 3 hours before Proctor's filing and not exactly 30 minutes after it. Therefore, the court's conclusion that there's been a violation of its impoundment order is based on a factually inaccurate premise. The court's actions as a result of what it incorrectly determined was a violation of its order has primarily impacted Reed, who's the party who subpoenaed Proctor, began taking his deposition, scheduled a second day of testimony, and has spent significant resources compelling and taking his testimony. Because there is no evidence of any violation of the court's impoundment order, and because the court did not permit Reed's counsel to present any evidence at this point at the July 1st hearing, the court should now clarify that no violation took place and permit Reed to proceed with her scheduled day of depositions on July 14th. XOXO, Karen Reed's attorneys, Damon Seligson, Aaron Rosenberg, Charles Waters, and everybody else, including Alan Jackson, Elizabeth Little, etc. This was July 2nd of 2026. Well, Here's my concern. Well, let's look at the judge's order, because we found the judge's order was the first thing that came out. Okay. That was the first thing that came out. So we've already read it, but now we have to read it again, knowing what we know. Okay. So that was filed first. And this was filed this was filed after. So this is dated July 6th. So 4 days later, the judge issues this, docket number 152 on the O'Keefe versus Reed matter. Acknowledgement of various motions to clarify the record. Here we go. The court has received Ms. Reed's emergency motion to clarify the record submitted July 1, 2026. Right, we just read it. Remember, we didn't have it when this order came out. It wasn't on the docket. It wasn't there. Never scanned, wasn't filed, no access. Supplemental Memorandum of Law in support of the emergency motion to clarify the record submitted July 2nd. And motion to clarify the record submitted June 12th, paper number 127. It's no longer on the docket. But I think, what I think that was, going back in time, is I think that is when Damon Seligson wanted the judge to clarify what in the world the judge meant when he said that they owed Michael Proctor the courtesy of telling him that they were going to file the lawsuit against Canton PD and MSP. I'm pretty sure that's what it was. And if you think it's something else, let me know. I know we looked at it, but it has since been taken down. It's not on the docket anymore. That was filed June 12th, so it would have been after that emergency hearing, which we're going to have to look at in a few minutes. All right, moving on. The motions have been docketed, but no action is required on these filings as they are not the proper use of a motion to clarify. But that's so funny, Your Honor, because I'm going to pull up another clip where you said, listen, I'm not going to let you say anything right now in this Zoom hearing, but if you want to make a motion to clarify, go ahead. Right? I'll show you the receipt. Such a motion should be a targeted request to the court to provide clarification of a previous judgment, order, or ruling that appears unclear. Should not be used as an opportunity to respond to generic statements from the bench. That was far more than a generic statement from the bench. That was accusatory. It was a spanking. It was done publicly. And you didn't tell the public what that tweet was. And I don't know when Karen's attorneys found out about it, if it was before the hearing or after. I'm not sure. It's not in the court record, so we don't know. It should not be used as an opportunity to respond to generic statements from the bench, submit additional information, or seek to get a party's position into the record. Footnote 4, which says paper number 127 acknowledges that its purpose is to address and respond to the court's statements. Any similar motions sought to be filed in the future will not be docketed. Okay. All right, well, we're going to go back to the part where you said to do that. Because why do you keep changing your mind? If counsel wishes to bring to the court's attention information discovered after counsel's 6/26/26 letter to me, footnote 5, and then it says a motion for reconsideration in compliance with Superior Rule 9D would be the proper procedure. Okay. 6/26/26 letter to me, which says such letter and the June 25th letter from counsel for the non-party are provisionally impounded pending any further hearing on the issues raised herein. Okay, so he's talking about this letter. Which counsel sent you a letter on 6/26/26? Was it Proctor's attorney? Is that when Proctor's attorney sent you a letter with this tweet in it? Because you flipped the F out about it. And that was exactly the day after Proctor's half a deposition. Okay? exactly the next day. So there's a June 25th letter from counsel for the non-party, which is Michael Proctor. And I don't know what the June 26th letter is because we don't know that either. Maybe it wasn't done ex parte. Maybe he did notify everyone of that tweet. And then that's why the judge called that crazy hearing. And then maybe they knew exactly what it was about when they went in there. We don't know because it's a mystery. It's a whole mystery. With respect to the submissions of July 1 and 2, the only relevant order was to preclude further attempts to take discovery from a non-party pending further orders of the court. Right. You halted everything, all discovery with regard to Michael Proctor. Let's see. Who does that affect the most? Well, if you were really trying to prove a car accident, you would say that it would absolutely affect the O'Keefes because they need to prove there was a car accident and Michael Proctor is the one who investigated this car accident that didn't happen. And therefore, they need his testimony more than anybody. But if you really, really, really want to figure it out, you would say, of course, it hurts Karen Read the most because she needs to prove that they were framing her. All of a sudden, the plug is pulled. So you can't make a motion for me to clarify anything because the other stuff that I said into the record isn't really in order. The court invited counsel to come to an agreement to hold private personal information in confidence, which everyone is supposed to do anyway, I want to point out to you. Which the court would consider entering as an order. If no such agreement is filed before 4:30 p.m. on July 9th, that's tomorrow, the court will issue further orders it deems appropriate. Right. And he said that he could issue such sanctions as dismissal of the case, which would hurt the plaintiffs, or default, which means default of the defense, which means that Karen Read would automatically lose and they would just go to trial on the damages. But now that we know that this has to do with Aidan Kearney, I have grave concerns. I have grave concerns because here's why. Boop. There's a motion to compel Aidan Kearney to submit to a deposition in this case, and a motion for him to compel documents, including his phone extraction. Aidan Kearney's attorneys apparently didn't respond to it, and I have no idea why. So before they could respond to it, he issued an order agreeing that Aidan Kearney has to produce everything. And so Aidan Kearney is involved in this case, and Aidan Kearney is a defendant in the defamation case, also being heard by this judge. Okay. And now, based on the hearing, the judge thinks or thought Aidan Kearney was the leak and that Karen Read's attorneys leaked it to him. Fight me on it. That's why he had every single attorney and party, 32 of them, write an affidavit saying they don't know who did it and they didn't do it. So if the judge believes that Aidan Kearney was the leak based on the altered, proctored tweet that Proctor's attorney provided to the court, does that show a little bias against Aidan Kearney already? And should this judge really be deciding anything that has to do with Aidan Kearney in any way, shape, or form? I say no. I say no. Think about it. By calling this hearing and forcing every single attorney in this case to come into court on the Wednesday before the July 4th holiday weekend with 48 hours notice, including Alan Jackson, who had to fly in from LA, based on the information, which now we know was Aidan Kearney's tweet, which was altered, that's a problem. That's a problem. I think that Aidan Kearney's attorneys should be making a motion or accuse because he has told the world that he believes Aidan Kearney was the leak. And he's also privy to the defamation case. So he knows that the defamation theory against Karen Read and Aidan Kearney is that they conspired together to defame Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert. Isn't he a little bit biased now? I don't know. I'm just saying. He can't sit on this case. The appearance of impropriety has already been shown to the world because you believed it and it wasn't true. But now, how do you shake that bias? right? No, I'm not saying that Aidan was on the email chain with Proctor's lawyers. I'm saying that Proctor's lawyer sent a tweet to the judge saying, Michael Proctor's private information in his impounded affidavits was leaked. Here's the leak. It's Aidan Kearney's tweet, which happened 30 minutes after I filed those impounded papers. But it really didn't. It really happened at 10:52 in the morning. How can he possibly decide anything involving Aidan Kearney? I don't think he can. Because now it's out there. Now it's out there that he believed this thing and that he called everybody in. It's my opinion. Because now you're showing that you believe that Aidan Kearney was the leak and that Karen's team probably leaked it to him. I don't know. I got a big problem with it. Yes, we're going to look at that too. We're going to look at Larry Foreman's thing. Let's first look at the proof. Let's do this first. Well, I mean, we kind of have to go in order, right? So first, let's go to the emergency. No, we have to go. First, we'll go to Aidan Kearney's YouTube presentation, which would have been on June 6th. So let's go there first. I know it's a lot to take in, but we have to do this in order. Chronological order. Okay. Here's the presentation. This was on a Saturday, June 6th, 6/6/26. Here's Aidan Kearney telling us what some source shared with him. And I'm just going to zoom in on this so that the dirty words are not on the screen. Do that. Let's put them on regular speed. This would have been, I guess, the Saturday night show, 6/6, okay? This is before the filing on 6/8 or even 6/7, because 6/7 was the day that they really filed their papers, I think, on a Sunday, right? Okay. Let's listen to what Aidan had to say on his Saturday night YouTube presentation.
So actually, I got a hot take here. This is a tip I have. So he's trying to get out of it, and Judge Gildea basically responded to it. They dropped this on like Friday, last minute, and so they think Judge Gildea won't have a time to respond. But this is a tip that we got in the inbox, and again, this is like one of those disclaimers. I don't know if this is true or not, so I'm just reporting this as a tip. That's not necessarily 1,000% confirmed at all. It's 0% confirmed, but I'm just going to read it. Because when a tip has like slightly more juice than like a completely made up shit, this one seems to have slightly more juice. All right. I got credible info from my coworker. He spoke to Proctor's wife, and he is in a psychiatric hospital in Florida for treatment. He was at McLean's in Belmont, but left for Florida, and now he's being treated down there. I know from past comments from my coworker, but just learned about the hospitalization a couple days ago. His wife and him are absolutely done. That's confirmed. She has separated herself from him for obvious reasons. So again, this is unconfirmed.
Remember, because we're going to look at it again in the morning hearing on June 8th, it was very vague. Family issues, medical issues, it was vague. Aidan had this information 2 days before that hearing.
And they go on to say, he's not sure how long this has been going on for with the ex-wife in the exact time, but it's been at least 2 months because of the previous comments from my coworker about him being separated from his wife and in Florida or around 2 months ago. The coworker's wife is one of the best friends with Elizabeth Proctor. So the info is pretty solid. This kid that tells us this stuff only gives us info once in a while. It's not everyday conversation, unfortunately. He does have sympathy for Proctor, which I do not. And then Laura responds and goes, they might think differently now after the latest filing. And the source says, yeah, he's definitely changed his defense of Proctor from the beginning to now. Before, he was adamant that Karen was guilty and Proctor did no wrong. Now he has very little to say about Proctor's conduct. Tell Aidan all of us appreciate what he has done and is doing for civil rights. Replace him at the top of that moment in American history. Well, thank you very much. So again, unconfirmed, but sources are saying he's doing the rehab thing to try to get out of this. He might be in Florida. I don't know. But to me, that would make sense. I would go to Florida. Dude, what's he going to do?
He says it's unconfirmed. I don't know if it's true. It's unconfirmed. I get emails all the time. People, crazy stuff. You know who else once sent him a crazy email? Kate Peter once sent him a crazy email to see if he would run with it. Pretended to be a different person and said, Colin Albert is a drug dealer. He went public with it, as she knew he would or wanted him to, and then bragged about it on another YouTuber's show that she's the one who started that rumor by sending it to him to prove that he doesn't vet his sources, okay? So the Colin Albert is a drug dealer rumor started with Kate Peter, a.k.a. Mafia Masshole, which begs the question, was this a bump? Was this a bump? Knowing that if Aidan gets a tip like this, of course, he's going to talk about it. The problem is your bump was too soon because your bump came 2 days before the impounded information came out. Was it a bump or was it real? Let's listen more.
He's going to do, that guy? He's going to lose everything. His wife stuck by him because it's her goal in life to be married to a cop. Anybody who has ever said the word, we are part of a blue family, which she has before, if a woman says that, it's because she loves being married to a cop, loves it because of the status it gives her. She doesn't have to put her life on the line because she gets to brag about how her husband does, and she gets to, she's cool. I'm in a blue family and she has the blue thin line on her car. And when she gets pulled over, she doesn't get ticketed because her husband's a cop and all that stuff. And she gets to hang out with other cop wives and blah, 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 blah. And you're all getting cheated on, but that's different. Right. So, her dad is an FBI agent, Elizabeth Siracusa.
Michael Proctor's dad is an FBI agent. Elizabeth Proctor's dad is an FBI agent. Let that sink in. Let that sink in. I think I knew, but I think I forgot. Michael Proctor's father-in-law is an FBI agent. Right, Michael Proctor's father-in-law, right? Elizabeth Proctor's father. Listen again. He knows everything. He's got receipts on everything. He doesn't, he's hyperbolic sometimes, but I forgot about this.
Blah, blah, blah. And she gets to hang out with other cop wives and blah, 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 blah. And you're all getting cheated on, but that's different. Right. So, her dad is an FBI agent, Elizabeth Siracusa. Her brother is a detective for the Belmont Police Department.
Oh.
Who has investigated Towel News, I believe.
Oh.
There's been some phone calls to that house before. But because of Wendy Murphy, though. Wendy Murphy called. There was a dollhouse. It was a long story. Anyway, back to this. So Elizabeth, that would make sense if she wants nothing to do with him anymore. It would make sense if
he's telling us everything.
Doing the whole mental health thing. I mean, if you were him, wouldn't you? I would be. I mean, at the end of it, he's a piece of shit, and you'll never see me defending him, and I hope he's suffering. But he is a human being, and that's gonna there's no way that doesn't fuck. I'm not saying he doesn't deserve it, but he's human, and naturally, if this happens to you, that's gonna fuck with your head.
He's showing a little bit of compassion for Michael Proctor right here. Listen to this. I said this the other day on Billy Bush. I said, nothing is more dangerous than a person who's got nothing left to lose. And when we read all of those letters from Jen McCabe's dad and Matt McCabe and Kerry Roberts to like everybody in the government and one other person who was like, I don't know, somehow related or a girlfriend of Tim Albert in support of Proctor so that they wouldn't fire him. Think about that.
Right? And I'm glad it's fucking with his head. He deserves to have this fucking with his head. He's a horrible, horrible person. And I hope he is in mental hell right now. I hope every day for the rest of Michael Proctor's miserable existence. And I wish this on his wife too, not just him, to be very clear, because she married him and she stood by him and she knows exactly who Michael Proctor is. And she's only getting out of it now because she can't say she's married to a cop anymore. So he's no use to her. So she can go F herself as far as I'm concerned. But God, I hope he's in mental health. This mofo. Because you know why? Because that's what he wanted from me. Because he is a driving force behind my charges. And if I'm not charged, then there's no bail. And I don't get my bail revoked. And he wants to take me away from my kids. So you know what? I hope anybody that does that, I hope his life is horrible. I hope every day he wakes up with thoughts of wanting to off himself, but that he's too much of a pussy to do it. That's what I want. Because to me, suicide is the easy way out. I want him to.
Okay, so he's entitled to his opinions and he talks about his opinions a little bit more. But before we get too off track, something else happened. Okay, somebody else reported this. Larry Foreman, aka DUI guy, also got an email from a source. Let's take this down, put this up. So that was on June 6th. That was 2 days before, or at least 1 day before, Proctor's attorney filed anything. Larry Foreman, aka DUI guy, tweeted this on July 1st. I love and trust my fans. A lot of you email me with tips, suggestions, and compliments. This is an email I just got. So he got this on July 1st. I've never heard from this person before, so that's already sus. Source, trust me, bro. Could be the McAlbert's camp, could be legit. You decide. Proctor leak. It's an email from some guy named Mike something at yahoo.com. And I'm curious to know if this is the same guy that sent Aidan the email, but this was sent July 1st at 11:46 a.m. Hi, Larry. Love your content. I have firsthand info that Proctor's estranged wife leaked his mental health info well before the info was given to the court. She shared it with her friends that shared it with their husbands. One of those husbands is my coworker that shared it with me. That info eventually got to Turtle Boy well before the court ever heard of Proctor's motion to delay any deposition. So I don't know. Is it the same source? Is it the same writer? That tweet was not something that was cited in the court papers, not even like, we don't even know if the court was aware of this at all. But there are people talking that are not Turtle Boy, that are friends of the family, and say that his wife is the one who's telling everybody. I have some grave concerns. Let's go back and take a look at what the judge said. All the way back on June 8th. There was an emergency hearing on June 8th. For those of you who might have forgotten. Got to move that over here, over here. It was a Zoom hearing on June 8th. Proctor made an emergency motion for a protective order because he didn't want to come to his deposition. The deposition was supposed to be on June 8th, and his lawyer, Mr. Hamill, filed this for this emergency motion. And let's go back and listen, because it's interesting to go back and listen to things afterwards, because, hindsight is always 2020. Okay. Again, this is the June, what did I say it was? June 8th. This was June 8th hearing regarding Proctor's protective order. This is the one where they had a hearing in the morning and the judge says some stuff and he says, come back at 4:15. Okay. So we got to go back and listen to this now, because this is when Proctor's attorney should have already known that Aidan Kearney was on the internet 2 days before talking about Michael Proctor's mental health and the fact that he was somewhere in Florida, right? Because they watch every single show that he does, just like they watch every single show that I do. Okay, so he would have known this by now, I think. What do you think? Okay, let's listen. This is about, I told myself to go where? 2 minutes and 15 seconds in. Okay, hold on. This was, I think, thank you to Child Channel for posting this, courtesy of Grant Smith Ellis, who I think is the only one who got the live feed of this. I think I was away when this happened. I don't remember now.
We believe that the
Heard further. Okay. Attorney Hamill, do you want to be heard further?
yes, Your Honor. We believe that the motion we've submitted in the materials that are provisionally impounded that we submitted to the court per the court's order readily support impoundment of those materials under Rule 2. We feel that we've put the majority of what we need to put into our papers, but for the court's information, within hours of our firm sending to the clerk and to counsel the motion and the 2 affidavits, which are provisionally impounded per the court's order, within hours, my client and his family members received harassing phone calls containing.
There it is. Within hours of them filing their papers, he says Proctor and his family were receiving harassing phone calls. Listen.
The 2 affidavits, which are provisionally impounded per the court's order, within hours, my client and his family members received harassing phone calls containing, pertaining to information contained in those affidavits. I think it's safe to assume that the clerk's office did not disseminate that information on a Sunday afternoon, Your Honor.
Okay, so he's saying the harassing phone calls came on Sunday afternoon, which would have been on June 7th, still one day after Turtle Boy's presentation. But the initial papers that were filed, Abe Lincoln present, it's hilarious, on the Sunday. Is the court clerk working on a Sunday? I mean, you may have e-filed them on a Sunday, but I don't know that anybody at the court saw them. And I don't know that they would have been publicly available on the Sunday. You guys tell me. But he's claiming that Michael Proctor and his family all of a sudden received harassing phone calls. See how many times he tries to get out of this deposition.
I assume members received counsel the motion for our papers, but we feel that we've put the majority of what we need to put into our papers. But for the court's information, within hours of our firm sending to the clerk and to counsel the motion and the 2 affidavits, which are provisionally impounded per the court's order, within hours, my client and his family members received harassing phone calls containing, pertaining to information contained in those affidavits.
I'm telling you, the clerk was not in it would not hit the docket publicly. Sometimes that, so he's now insinuating when we go back and listen to this, that it was somebody in one of the attorney's offices that leaked it. I don't know, call me crazy, but I think he's going to blame Karen Reed for leaking it to Aidan Kearney, who then rallied people to make phone calls. Again, another reason why I don't think the judge can sit on this case anymore, because he also has the defamation case and he just made an order that Aidan Kearney has to turn over everything. I don't know. I'm just saying. Wasn't the clerk. Okay, so listen.
I think it's safe to assume that the clerk's office did not disseminate that information on a Sunday afternoon, Your Honor. I obviously can't connect any dots, and I don't intend to do so here. But that is why we are seeking impoundment. This is obviously a very public case. I don't need to tell anyone that. But I don't believe that our client's medical personal information, a non-party to this case, needs to be all over the internet when we're just seeking a new deposition date.
Your Honor, if I may respond to the inference from Mr. Hamill about how whatever he filed on Sunday ends up on the internet, there is I categorically deny and reject.
Attorney Sullivan, he didn't point any fingers. He could have meant me. I don't know. So let's move on. All right.
See, he could have meant me. He didn't mean you. He didn't mean the judge. The judge wasn't working on a Sunday. Pat Ray pointing out that June 4th was when Karen Reed's Bristol filing revealed all of more Proctor's text messages, more disgusting, racist, virulent Proctor and Goods texts, right? So Pat Ray says they want us to think harassing calls started days after that. It's all in the timing. But again, he's putting it in the back of the judge's brain. Maybe, oh, it must have been Karen Reed's attorneys who leaked it to Karen. Karen leaked it to Turtle Boy. Therefore, we're helping prove the defamation case, Your Honor. You know, the collusion between the two.
Okay, thank you, Judge.
All right. Thank you. So the next issue is the motion before the court. Before we get to that, I find that there's good cause to impound the material that's contained in the affidavits, and I'm going to impound them provisionally at this time for purposes of this hearing. So, Attorney Hamill, do you want to be heard on your motion relative to the deposition?
Your Honor, just briefly, and I'd like to address a few things that were noted in the response of Ms. Reed. Again, we're seeking very limited relief in nature, Your Honor. We're seeking a new deposition date. 99% of the time, I could pick up the phone and call opposing counsel, and this would be resolved without the need to involve Your Honor in the court. That's not the case here. Ms. Reed's opposition.
Attorney Hamill, hang on. I mean, normally you could, but normally it wouldn't be 4 or 5 days before the scheduled deposition. The information that you're relying upon would have been provided much sooner than that.
Understood, Your Honor. And I know Your Honor had a few specific questions in the order that was put out last week, including when we learned of that the circumstances of Mr. Proctor's unavailability late Thursday. We informed counsel of his unavailability first thing Friday.
Right, Friday. The deposition's supposed to be Monday, the same day that this Zoom hearing is. Look at Fire Pilot's wife coming in here and gifting 20 memberships. Thank you so much. You were so generous. Craftastically gifted 5. You're amazing. You're all so amazing. I love you so much.
I fully agree that the timing is unfortunate there, Your Honor. Ms. Reed's opposition seems to suggest that we first reached out to our clients on Wednesday, June 3rd, about his deposition. That's false, and that's not in the affidavits. We communicated with our client about the deposition back in April when we agreed to reschedule the deposition at Ms. Reed's counsel's request. Again, we intend to produce Mr. Proctor for his deposition, but given the circumstances set forth in the provisionally impounded affidavits, we need a new date, and we believe we have put good cause on this record to obtain a new date.
You state you'll produce him, but you don't give an indication in your filings when.
Yes, Your Honor. As noted in the impounded materials, my client's situation is ongoing. We are in constant communication with him, and we will provide dates as soon as possible to counsel. I understand we are on Mr. Proctor's not a party to this case, but we understand that the court is on an accelerated discovery schedule with a August, I believe, discovery deadline. We can get dates to counsel by the end of the week, if that would be satisfactory, and would be happy to provide us.
All he says is that the situation is ongoing. You mean to tell me when he did the Zoom hearing on the 8th, nobody had told him about Aidan's show on the 6th? I don't buy it. I just don't buy it. But let him keep talking. I'm just going to speed it up a little bit. Oops. Oh no. Oh no. Where were we? Hold on, I got to rewind my own feed to find out where we were.
Which I understand the judge, you judge, you're going to.
Would you like to offer anything else, Attorney Hamill?
As noted in the impounded materials, my client's situation is ongoing. We are in constant communication with him, and we will provide dates as soon as possible to counsel. I understand we are on Mr. Proctor is not a party to this case, but we understand that the court is on an accelerated discovery schedule with a August, I believe, discovery deadline. We can get dates to counsel by the end of the week, if that would be satisfactory, and would be happy to provide a status report to the court on that once that's done.
Would you like to offer anything else, Attorney Hamill?
Thank you, Susan.
No, Your Honor. Beyond what's in our papers, we'll rest in our papers. Thank you.
Attorney Seligson.
Thank you, Your Honor. Obviously, we are opposed to the motion for protective order. This is a duly noticed deposition. The subpoena for the deposition went out in April. There was an agreed upon date of June 8th, which we have prepared for, we have strategically planned for, we've incurred costs. Now,
Oops. He said strategically. The judge didn't like that. Thank you, Susan, for gifting 5. You're amazing.
4 days before the deposition, suddenly there is a need to continue it. There is no, other than conclusory statements, which I understand the judge, you judge, you're going to impound, but other than conclusory statements, there's no evidence provided of what exactly is the reasoning for family commitments that may be impacting the ability to attend today, health issues that are causing the inability to attend today, to seek a continuance on the eve.
That's all the original paper said, by the way. Family commitments and health issues. Listen.
Commitments that may, what exactly is the reasoning for family commitments that may be impacting the ability to attend today, health issues that are causing the inability to attend.
So even if somebody did get a hold of the Sunday papers, and started making harassing phone calls, all those papers said was he's got family commitments and health issues. That's it. That's all it said.
Today, to seek a continuance on the eve of such an important deposition after we have incurred so much time, effort, and expense, including travel. Attorney Jackson traveled from California here to conduct the deposition, and we planned around that and strategically planned around that. And the schedule that Your Honor is keeping us to, this is highly prejudicial to my client. The reasoning is not sufficient. Mr. Proctor says in his affidavit that his attorneys had contacted him on June 3rd to discuss and prepare for his deposition. And then we learn on June 4th that they're not coming after we seek out simple list of attendees so that we can give it to the security desk. At no point from April until June 4th did we learn that there was any issue. Was there any request for any continuance, any request for any accommodation? And we've prepared and incurred costs and expense getting to this point. And we're here today in strong opposition to the deposition being continued.
Attorney Seligson, you used the phrase strategically prepared for.
Yep.
And
Yes, Your Honor.
it raises a question in my mind relative to the new Bristol action that you filed last Thursday, I think.
Yes, Your Honor.
And Ms. Reed's attorneys were fully aware that Attorney Hamill's office was involved on behalf of Mr. Proctor, correct?
Yes, Your Honor. For the deposition in this case, yes.
Okay, once again, if you're just tuning in, this is the June 8th hearing. The June 8th hearing, the one that took all day because they come back at 4:15. But the judge is now saying that he's got concerns about the timing of the filing of their lawsuit, which was filed 4 days before Proctor's deposition, and why they didn't give him notice. Here's the thing. Proctor's not a party to that lawsuit. That lawsuit that Karen filed involved the Massachusetts State Police and the Canton PD. Okay? Michael Proctor is, or was, a member of the Massachusetts State Police, but he's a defendant in the other case that they removed to federal court. Okay? Everyone knew this lawsuit was coming because they had to wait the 6 months presentment period to file it. And they've talked about it in hearings before that it was going to be filed. There is no rule, no obligation on the behalf of Karen's attorneys to notify Michael Proctor about a lawsuit that's going to expose some of his really disgusting text messages. And maybe that's just why he had a mental health crisis at this exact time, because look how many days passed between the filing of that lawsuit and this hearing. This is the 8th. I think, did you say that lawsuit was filed on the 4th? And the judge even said it 4 days before. Shouldn't you have told him? There's no notice requirement anywhere.
Was notice of that involved on behalf of attorneys were fully aware that, and new Bristol Act raises a question in my mind relative to the new Bristol action that you filed that was filed last Thursday, I think.
Yes, Your Honor.
And Ms. Reed's attorneys were fully aware that Attorney Hamill's office was involved on behalf of Mr. Proctor, correct?
Yes, Your Honor. For the deposition in this case, yes.
Was notice of that intent to file the Bristol action given to Mr. Proctor's attorneys?
No, Your Honor. Firstly, I want to be respectful of the court's inquiry. I also want to be careful how I discuss our strategic attorney work product, attorney-client planning. When I say strategic, I mean sequencing of depositions. Nothing to do with the Massachusetts State Police complaint we filed. Those dates there wasn't some kind of effort to impact the deposition with the filing of the complaint, if that's what the court is asking. Strategic, as I stated, was with respect to sequencing of depositions in the wrongful death case, which we have been talking about as a team for months. That's what I mean, Your Honor.
Okay, thank you. Anything else, Attorney?
So that lawsuit dropped on the Thursday, and then this hearing was the Monday, okay? And that's the day Proctor was supposed to show up.
Seligson?
Your Honor, what I'd like to do is ask the court to deny the motion. And if the court's inclined to grant the motion, we would ask that we be entitled to submit a petition for our fees and costs in having to redo the prep, redo the logistical planning. But again, we'd ask that the motion be denied and that Mr. Proctor arrive for his deposition today and that we conduct it as noticed.
Thank you. Attorney Buck, do you want to be heard?
Your Honor, I just want to make it clear for the record that the plaintiffs intend to seek testimony from Mr. Proctor, but don't take a position as to whether that testimony is taken today or in the future.
Thank you. Attorney Rose, do you want to be heard?
No, Your Honor, we take no position with regards to the motion.
Attorney Daly?
No, Your Honor, thank you.
Okay. Thank you, everyone. We're going to take a short recess and I'll come back out. Thank you.
Thank you.
Okay, so the judge does a little timeout and then he comes back, and this is still in the morning of June 8th. So listen to what he says when he comes back. He had to go take a timeout and think about it.
Thank you, Your Honor.
Right, all lawyering is strategic. That's right. This is after the break.
Your Honor, we return to the record on the matter of O'Keefe versus C&C Hospitality LLC, and all counsel was present.
Thank you, Mr. Clerk. Mr. Clerk, I'm handing the clerk an endorsement on the motion before me, and I'm also going to read it into the record. For this case to...
Okay, so he went back to do his timeout, and while he was there, he wrote another speech, but this winds up being the endorsement on the motion, all right? Unfortunately, because Judge Gildea sits like 7 miles away from the camera, we can't see him. He's in this little teeny weeny box down here. And I think this is when that guy Brendan comes in and drops the F-bomb. So I'll try and zoom in on the judge, but I don't know if he's going to get any bigger. Okay, here's his prepared speech for this.
motion before me, and I'm handing the clerk an endorsement on the motion before me, and I'm also going to read it into the record. For this case to proceed efficiently and for our system of justice to work, certain basic things have to happen. A subpoena needs to mean something. A lawyer's agreement needs to have some meaning. Lawyers need to communicate with their clients. Clients need to keep their attorneys informed. And when given an opportunity to provide support for a party's request, that party needs to avail themselves of the opportunity. Based on the record before me, there is insufficient information to support a delay in the deposition going forward. However, given the claims made in the filings over the weekend, I will delay making a final decision on the motion until 4 p.m. today.
Right. It was too generic, so he couldn't decide because all it said was family commitments and health issues. So he gave Proctor's attorney until 4 p.m. To submit some more information, some more detailed information about Proctor's exact reason why he can't come. Okay.
To give Mr. Proctor's counsel the opportunity to supplement the record before me. The subpoena requiring Mr. Proctor to appear for deposition today is stayed for 24 hours. Further hearing will be held today at 4:15 p.m. by Zoom. I followed up with Attorney Seligson on his reference to strategically preparing for the deposition today because I read in the media of an...
If your mind has started to wander because you think you've heard this before, come back to me, circle back and listen to this again.
Preparing for the deposition today because I read in the media of an appearance on the Today Show Friday morning.
I'm sorry, you read in the media about an appearance on the Today Show Friday morning? You're not supposed to be doing any outside research, Judge. You read in the media about Karen Reed's appearance on the Today Show? I'm sorry, what? I'm going to rewind that again. I thought this wasn't supposed to be a spectacle. This is going all the way back to June 8th, my friends. This is a month ago. Today's July 8th. This is June 8th.
On his reference to strategically preparing for the deposition today, because I read in the media of an appearance on the Today Show Friday morning where Ms. Reed said that her new civil lawsuit was always part of a plan that she has. And beside her were attorneys Alan Jackson and Charles Waters, who cast the case as a bid to expose institutional corruption in Massachusetts law enforcement.
Does that scare you? Does it scare you that Karen Reed intended to sue to expose corruption in the Commonwealth of Massachusetts? Institutional corruption? Does it scare you? Why are you watching the media? This is crazy. Listen again. Maybe he read it in the TV guide. You're right.
Alan Jackson and Charles Waters, who cast the...
He didn't read about it in the media. It sounds like he watched the Today Show interview because if he saw her attorney sitting next to her, then he definitely watched the interview, right? How can he be impartial? He's not supposed to be doing his outside research.
Case as a bid to expose institutional corruption in Massachusetts law enforcement and to hold someone accountable for the death of her boyfriend, Officer John O'Keefe. Although there is no duty on Ms. Reed's counsel to have informed Mr. Proctor's counsel of the intent to file the most recently filed Bristol County action, I think it is unreasonable to have not done so with a scheduled deposition pending and then to have filed such action 4 days before the scheduled deposition. The actions by counsel, Mr. Proctor's counsel seeking to continue the deposition at the last moment, and Ms. Reed's counsel filing its new action 4 days before the scheduled deposition with an obviously planned appearance on national television, brought to mind comment 4 to Rule 3.5 of the Massachusetts Rules of Professional Conduct.
And again,
wherein it is stated,
he's citing ethical rules, which is a not so veiled threat to the attorneys that he could report them to the Bar Association, or the BBO is what they call it in Massachusetts, for them violating some ethical rules about not giving Proctor notice about this lawsuit that we knew was going to be filed against the MSP and Canton PD. Now this confirms for me that that's what docket number 127 is about. Karen Reed's team wanted a clarification of what exactly the hell he's talking about. Why is he telling the world-wide audience that that Karen's team could be violating ethics by not giving Michael Proctor's team or Michael Proctor's attorney notice that they were going to file a lawsuit that is not including him as a defendant? It's wild. It's improper, to say the least. And so when paper 127 was filed for a motion to clarify the record, like, what exactly did you mean? Why did you say we had to give him notice? There's no rule that says we have to give him notice. There's no case law that says we have to give him notice. Why did you say that to a worldwide audience? And wait, because there's more.
The advocate can present the cause, protect the record for subsequent review, and preserve professional integrity by patient firmness, no less effectively than by theatrics.
So you're saying that Karen Reed's team is being theatrical and they have no integrity? Because that's what it sounds like to me.
As St. Mary's University School of Law Assistant Professor David Bernardo noted years ago at a conference.
Well, at least he credited that guy. He didn't credit the Brandeis freshman who talked about the algorithms and the pixels and the other things.
On professional responsibility. Civility in the legal profession is generally defined as treating others, opposing counsel, the court, clients, and others with courtesy, dignity, and kindness.
Are you saying that her team is unkind and discourteous and uncivil?
Thanks for appearing this morning. We'll see everyone at 4:15 this afternoon.
Are they not allowed to have strategy?
Thank you.
For the record, this matter is continued to 4:15 this afternoon for further
Ms. Elgin,
hearing.
not happy. Now they come back at 4:15. Here we go. This is again, June 8th. Monday, June 8th.
Your Honor, may I proceed? Please. Your Honor, for the record, civil.
So this was at 4:15. As we know from the other orders and the other motions that we've read, at 2:22 p.m., that's when Abe Lincoln, aka Matthew Hamill, which is funny because there's another guy named Lincoln Rose on the screen. 2:22 p.m. This is the same day as the day that they filed the additional information with the affidavits from what I'm assuming is the medical provider. At 2:52 p.m., that is when the tweet was altered. Aidan Kearney's tweet was altered to read 2:52 p.m. We know it was at 10:52 Eastern time. Somebody sent it to Proctor's attorney, apparently in UTC time. But again, not until 3 weeks later, allegedly. Okay. Let's hear what the judge says at 4:15.
Action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus C&C Hospitality LLC, doing business as C.F. McCarthy's et al. Counsel, if you please identify yourself for the benefit of the court of the record, starting with plaintiff's counsel.
Good afternoon, Your Honor. Dan Buck with Kristina Borante for the plaintiffs.
Good afternoon.
Good afternoon. Good afternoon, Your Honor. Lincoln Rose on behalf of the defendant, C.F. McCarthy's.
No, we knew they went back because
Good
they did a
afternoon.
hearing they did a hearing in the morning and they said you have to come back at 4:15. It was like a whole day thing. It was like a whole day thing. We knew. I don't know if we watched it, but yes, we did.
Good afternoon, Your Honor. Sarah Shipley for the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Damon Seligson for Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg for Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Attorney John Dilly for the defendant, Waterfall.
All right, I need to just skip through these introductions because we don't care about that. All right, so Abe Lincoln is going to come back and have a little something to say. Wait, where is it? 17, right around here.
Alan Jackson.
Good afternoon.
And good afternoon, Your Honor. Matthew.
Further.
Your Honor, beyond what we put on the record earlier today, I believe we're satisfied with what's on the record and the additional materials we've submitted to the court, provisionally impounded. Thank you.
Okay. Before I hear from Ms. Reed's attorney on the issue, does Ms. Reed's attorney want to be heard on the motion to impound the submission?
Your Honor, I can tell from the substance of what's been filed that is going to be impounded. So I don't have an opposition to the motion to impound what has been filed this afternoon. But I would like to be heard from on Ms. Reed's behalf and what we discussed this morning.
We'll get there. So I'm going to have a hearing on the issue of impoundment. I find good cause for the same reasons I did this morning, and I'm going to order the attachments to be impounded. So, Attorney Seligson, I'll hear from you on the request in light of the supplemental submission.
Your Honor, the arguments for Mr. Proctor's deposition being continued continue to change. At first, he was argued to be just a mere witness who couldn't attend because he was unavailable. Then they argued that he was also unavailable for his deposition because his counsel had trials. Now they're arguing that he cannot appear for the reasons submitted in the affidavits. And now we are wondering, based on what was submitted this afternoon, can he even appear? Or are we going to put this over for a couple of weeks so we can get a new date? So I'm a little concerned and troubled by, so the relief keeps changing. They said in their submissions on Friday and then on Sunday that he knows he has to appear and that he will appear. And now this afternoon, we see something that's more long-term. So I'd like to find out about that from the court and counsel for Mr. Proctor. I'd also like to address, Your Honor, some of the statements that were made this morning by the court and that ended up in your written decision.
Yeah.
Your Honor.
Attorney Seligson, you don't need to address that. You heard what I said. You might not agree with it, but we're not here for that right now. We're here we're here for the issue. So do you want to add anything else on the substance of the request before the court?
Nothing on the
He's talking about the statement about him having to give notice to Proctor, and you should have given him notice.
Substance before the court, but I would like an opportunity. I'm compelled to put something on the record to preserve my client's rights, Judge, and I'd like to do that if given the chance, and I would be brief.
Your client's rights were in no way impaired by what I stated.
Really?
So we're going to move on. If you're all...
I don't know. It showed a little bit of bias. It sounds to me like you called the attorneys discourteous, uncivil, violating the rules of ethics. I don't know, dude.
Done with the substance of the request. Okay. So Attorney Hamill, do you want to add anything further?
Your Honor, I'll just add that the relief has not changed in our view. From the start, we have sought to get a new date. Again, we're not seeking to preclude Ms. Reed from taking this deposition at all. We are simply seeking a new date for the reasons that we provided to the court already and the reasons we've already put on the record.
Okay. Does anyone else want to be heard?
Nope.
Hearing from no one? I didn't hear that. I'm sorry.
Your Honor, I guess without sort of running afoul of what you've just said to me, there is a question about notice. You've injected a different type of notice requirement that is perplexing to me and my colleagues about notice of things in advance of depositions, and that's what I was trying to seek clarification about.
Attorney Seligson, the great thing about this process is if I issue a decision, we generally don't engage in a discussion or dialogue about it. You can appeal something if you want to. If you want to submit something in writing for clarification, but I'm not going to engage.
Oh, that's so funny because they did. Docket number 127 was a motion for clarification of what you just said, and you just said that you're not going to hear it. That was your ruling on July 6th, is that no action is required on these filings because they're not the proper use of a motion to clarify, when you just said you can make a motion to clarify. Am I right? Or am I right? Listen to that again.
Issue a decision, we generally don't engage in a discussion or dialogue about it. You can appeal something if you want to. If you want to submit something in writing for clarification, but I'm not going to engage in a dialogue back and forth. That's not why we...
And you also refuse to address 127, which was the motion to clarify the record. You said it's improper when you told him that's exactly what he should do.
Here right now.
Understood.
Okay, so thank you. So I find that the supplemental submission does not provide sufficient support to grant the extraordinary request before the court, which is to continue a long notice deposition, which was scheduled on a date agreed to, and the request in effect is made 1 business day from the scheduled deposition. The timing of the request remains a concern. In addition, I am not convinced that the signatory of the letter submitted is qualified to give the opinions contained therein. Even if there had been a...
So whoever signed that letter, he says is not qualified to give the opinions. He's not buying what they're selling. Whatever they submitted in there is sealed affidavit from whatever, I'm assuming it's a medical provider, but maybe not. but that's what I'm assuming because he has told everyone that what Aidan tweeted about him being in Florida in a mental health inpatient treatment is true. Right? I mean, he just confirmed that all of it is true. But he didn't believe it because here's what he says, something about committee.
Curriculum vitae give the opinions that the signatory of the letter submitted is qualified to give the opinions contained therein. Even if there had been a curriculum vitae submitted.
No CV.
Sorry, I totally muted that line accidentally. I just saw
And here came Brandon. Brandon came in and dropped the F-bomb, but.
Oh, okay. There was one I clicked and I was like, fuck, was that it? Okay, cool.
Brandon, this is why we can't have nice things. This is why we can't play the Zoom on the air because people like you come on and other viewers don't know how to, mute themselves. And then this happens.
Okay. Even if there had been a curriculum vitae submitted, I am not convinced that it would show qualifications to give such opinions. The opinions are general in nature, do not provide any detail relative to the information referenced in the first paragraph of the letter. The opinions turn the request to, in effect, a request to continue a deposition indefinitely, which is contrary to what Mr. Proctor's counsel stated this morning.
Mm-hmm.
Of further concern is that the opinions appear to be by committee, without all committee members signing on to the opinion. Finally, the date.
Where are my mental health professionals in the chat? What does that mean? An opinion by committee. Can anybody translate that for us? I know someone can because you guys are wicked smart. Or do you think it means something else? Opinion by committee. Huh.
In the letter shows is that the opinions appear to be by committee, without all committee members signing on to the opinion. Finally, the dates in the letter show that the issue before the court could have been handled much earlier.
Oh, so what you're telling us is that if Michael Proctor is inpatient somewhere, he's been there for a long time, could have been handled much earlier. Okay.
The motion for a protective order is denied. The witness shall appear tomorrow for deposition at the place and time set forth in the subpoena.
Oh,
Your Honor.
Okay. Thank you very much.
Whoever that was,
Sullivan,
Instagram at Dirtbag said, oh, Fork to Spoon says it means that the psych board met together to see if it was okay for him to testify. And they said, no. Thank you, Fork to Spoon. The Clown Committee of Canton, says Zoe. So the judge didn't buy what he was selling. I know we covered this because my head popped off. And then he got muted, the judge.
Your Honor, you were muted there. We didn't hear what you said.
Damn.
Your Honor.
Your Honor.
We didn't hear, you got muted. We didn't hear what you just said.
A lot of you are saying treatment team, that he must have had a care team or a treatment team. And they all don't agree because he was eventually deposed. Okay. Okay. You need a committee to agree to hold you on a section, says Fiona. Oh, I see. And at Cupcakes 66 says, without telling us he was an inpatient, we were told he was an inpatient. Oh, interesting.
Okay. Did you hear anything?
No, you said Attorney Seligson, and that was it.
Your Honor.
It was brilliant, I'll tell you that. But Attorney Seligson, I was apologizing to you if you felt that I cut you off. But the issues you were raising are not the reason why we're here at 4:30 in the afternoon. All right.
I understand, Judge. There is one issue, just very brief, is the deposition. We appreciate the fact that the deposition is ordered to go forward. And ordered to go forward tomorrow is problematic. We'd like to get with counsel for Mr. Proctor and get a prompt new date that works for us.
And that's when my head popped off. I was like, I'm thinking to myself, you got to get this done because there's going to be way more shenanigans, tomfoolery, and ballyhoo to come. Like, you got to do it tomorrow. Alan Jackson was in town. They must have had multiple days blocked off. You can't tell me that they were not going to go in a row until it was done. And if Michael Proctor was in Florida, how did the judge expect him to hop on a flight, at 4:15 p.m. to be there in the morning for a deposition? So it makes me wonder if he's really in Florida. Tweety says committee is likely a treatment team and not one person wanted to take full responsibility. Maybe he had already been discharged. So I don't know. And so then that happened. And then the deposition did go ahead on the 25th. And then on the 26th, that's when Matthew Hamill, Michael Proctor's attorney, sent the judge the tweet that happened on this day, which he says was at 2:52, which really was at 10:52 a.m. And that's why sometimes we have to go back in time. Brian Tully is supposed to be deposed today. Does anybody think? I can't put closed captions on. I could have put it on for that. Sorry. But it's too late. But when I'm live, you can't see my closed captions unless you put them on your end. So you can do that. You can always put them on your end too, Yep. Oh, Jeannie says, Melanie, when they sectioned Karen, the team just took the word of the arresting officers. So now it's a thing that a committee is needed. Oh, that's interesting. That's in Massachusetts though, right? Jeannie? Kerry is a talker, says, I've never seen a committee need to sign off on a patient. That would breed confusion and mistakes. Yep. Well, they didn't depose him the next day. So then what had happened was, apparently, 25th, Proctor comes in, 12:30 to 5, does his deposition. Maybe he had a panic attack, maybe not. That was out there on the internet from another source to Turtle Boy. Then the judge calls an emergency hearing. After the next day, he's advised by Proctor's attorney that there was this leak all the way back on what he says was 30 minutes after this June 8th filing was made. They have the emergency hearing July 1. Judge issues this acknowledgement on July 6 after giving everyone a public spanking. And he stayed the deposition as to Michael Proctor and any discovery as to Michael Proctor all of a sudden out of the blue on July 6th until if and when they submit an order to his liking that is, like more harsh than a gag order or more harsh than the, confidentiality that they're already supposed to abide by under the rules. And they have until 4:30 p.m. tomorrow to do that. And they can agree on everything. So you think they're going to be able to agree on anything? Now, also of note, the motion to compel Aidan Kearney to comply with the subpoena was filed and the order was issued on July 3rd. You see the timing of all this stuff? See what's going on here? The order on the motion to compel Aidan Kearney was granted on July 3rd, directing him to turn over everything because his attorneys didn't respond. And the reason I could think he didn't respond is because he wasn't served. And also, they know exactly who Aidan Kearney's attorneys are because he's a defendant in the defamation case. It's not like they didn't know who he was, who the attorneys were. So, and also he moved. So I really don't know why, but I'm sure there's going to be a motion to something, a motion to reconsider. Okay. And then what had happened was Karen Reed's attorneys, made a motion, in this case, in the O'Keefe versus Reed matter, asking for an adjournment of the July 14th hearing. Because on July 14th, they also, wait, let me just make sure that that's the right date. Hold on, I got to go back to my calendar. Yes, originally, there was, on July 14th, a 2 p.m. anti-SLAPP hearing in the defamation case, also in front of Judge Gildea. 2 p.m. So it's not this case, it's the other case. It's McCabe, Albert, Higgins, and Colin versus Karen Reed and Aidan Kearney. The anti-SLAPP motion hearing was supposed to be July 14th at 2 p.m. and they have to be in federal court on the Reed versus everybody case at 3 p.m. and they're 40 miles apart. So Karen asked for an adjournment of that hearing into sometime later in August. Of course, the Haas plaintiffs opposed it. And instead of adjourning it into August, the judge said, you know what, we're just going to do it at 10 a.m. so that you can then get to federal court for 3 p.m. So that's where that stands. But now what had happened was Karen Reed just filed a motion in federal court to ask the federal court if they would adjourn it. And so the federal court has ruled today that everybody in that lawsuit, all the defendants that removed it to federal court, will have until tomorrow if they would like to file opposition to that, because hearing is coming up. Let me go to the chat first, and then we're going to take a look at the motion. Did you see that the O'Keefes want all of Karen's medical records and all of the medications she was taking on January 28th and 29th of 2022? And they also want her financial records for those 2 days so they can track her movements and her spending, because we can look at that next. Yeah, I'm going to show you why they want it, and I'm going to show you. It was like they want her to supplement her interrogatories. Interrogatories are a list of written questions that they can ask you before your deposition. We know she's already given one deposition, or she's completed 1 day of deposition on June 24th. They're going to pick another day, but they want her medical record. Well, we're going to talk about it. Let's go to the chat first. Deborah Walters, thank you for your 20. I appreciate you so much. Jill, not Wendy, says, I'm going solo from Texas to North Carolina to see my favorite band, War on Drugs. Cuz, buy the tickets. Thanks for inspiring me. Oh, I love that so much for you. Oh, have a great time, Jill. Not Wendy. Thanks for your 5. Villanelle, caught up on the Tully vid yesterday. Meatball and Jen impressions had me laughing so hard. My dog thought there was something wrong. Just wanted to say thanks. Oh, that's hilarious. Thank you for tuning in from Australia. I appreciate you and your super chat. Craftastical says the judge needs to be schooled about the conduct of the other side. They will stop at nothing to create havoc. His knee-jerk reaction makes him look stupid. He needs to stop joining the shenanigans. I got a lot of questions about where this information is coming from, but you know me. I always have questions. Thank you, Craftastical. Phil Gallagher is here from Liverpool. And here's Sherry Thompson, whose tweet was quoted in the papers. Says, guilty, it was me. I have never laughed so hard. We're both in the papers now. Well, I was in Marcy's emails. I wasn't in the papers. Michelle said, can Reed's attorneys ask to remove the judge? Yes. He brought all this drama in. Yes. Reed's attorneys can. Aidan's attorneys absolutely should, because he's already shown the world that he thinks that Aidan Kearney was leaked the information and that he's the one who published Michael Proctor's private information. So I think that's a good reason. But we've seen the way motions to recuse go before, because in Massachusetts, motions to recuse are decided by the judge who is supposed to recuse themselves. And didn't go well with Judge Kearney. Other states, we've seen motions to recuse where a different judge will hear it, but not in this case. He would be the one to hear it. Thank you, Michelle, for your 5. Bill Ness says, sorry, it wasn't the Tully video. It was the 6-hour video, because I was shocked. Oh, yeah. Okay. Thank you so much. I appreciate you, and I appreciate your super chat. Craftastical. Diller provided incorrect information to the court, was admonished. Proctor's attorney has done the same thing. The judge has to see what's going on to recuse himself, right? Remember, Diller wrote in his motion that Karen Reed's voice recording said something like, I'm dead, I'm effing dead if they see what's in my phone. And what she really said was, again, effing again. Proctor, that was the O'Keefe attorney, Diller. But we saw earlier Matthew Hamill tell us that Michael Proctor and his family were getting harassing phone calls on a Sunday after his filing. Okay. Abigail says the only other judge I've seen so many lawyers agree on being recused was Judge Kearney. I find that quite telling. It's interesting. Pat Ray says on June 8th, Proctor alleged Karen Reed's team leaked info from his June 5th filing. Gildea refused to address the leak. So what changed? He found out it's Aidan. June 8th, Proctor alleged Karen Reed's team leaked info from his June 5th filing. I thought that was the one that was filed on the Sunday. Yeah, that's what I think. He found out well, yeah. And he found out exactly what the tweet was, but back then they didn't say it was a tweet. See, the tweet wasn't provided to the judge until it was the day after Proctor's deposition. But I see what you're saying. I see what you're saying. Just South of History said they thought Turtle Boy would vet the tip and report it Tuesday, but he didn't. He reported it Saturday, maybe, if you think it was a bump. Pat says, those emails are textbook Kate Peter. I worry she's playing Aidan to sabotage Karen's case and is working. Gildea is not capable of handling this mess. Sound of Serenity says, same, trust me, bro. From and for elite law enforcement. Thank you, Sounds of Serenity, for being there for 3 months. Pat Ray also said June 4th was when Karen's Bristol filing revealed Proctor's text. They want us to think harassing calls started days after that. And Letter Rose by Better Rose said this was all done by design to make it look like Turtle Boy and Karen Reed, along with her attorneys, are in cahoots together. That's their whole case, isn't it? Yes. Yes. That's the defamation case, pretty much. Overruled. Sit down. I'm playing catch up. There's not a facility named McLean in Florida. McLean is in Massachusetts. Yes, we know that because Lindsay Clancy was in McLean for a time. But didn't he say that they was transferred? He was transferred from McLean. I don't recall exactly, but I'm sure you guys in the chat are paying attention and you know all the details. Edward says Hamill blamed Karen's lawyers for Good's letter leaking, even though at the time it was always known it was. That's right. That's right. That too. It was Hamill that did that. Okay. Hamill blamed Karen's attorneys for leaking Good's letter, his suspension letter, his letter of suspension, Sean Goods, even though at the time it was already known that it was Queen Corey Hopkins who got that letter pursuant to a FOIA request. You are right. You are correct. You're correct. Thank you, Edward. Revive. Andrea, the judge should have done his due diligence to ensure the implied accusations directed at Reed's attorneys and Turtle Boy was validated before he used his bench to slander them with the false evidence. Yeah, and you know what? He had 48 hours to do it, at least. At least, because I think he called for that hearing on 2 days prior. Like it was the Monday and they had to be there by the Wednesday. And I remember thinking it was crazy that they were going to only have 48 hours notice to get there. Like they have 0 other cases in person and Alan Jackson flying in. But listen, if you're admitted pro hoc in a case from California to a case in Massachusetts, you're going to have to be expected to do whatever the judge wants at the drop of a hat. So, I mean, can't really complain too much about that, but you're right. He did have 48 hours to validate it and he didn't because that was it was a knee-jerk reaction in my opinion. Andrea says, Judge Gildea so easily believed Karen's team leaked it. Why? I think he's been biased against Karen and Aidan from the start. Now it's obvious. Thank you, Andrea, for your opinions. Emma Sue says the Sandy Hook family's got a default judgment for failure to provide discovery. Should Karen's attorneys do the same? No, he wants to, what he's saying is Karen's attorneys, the remedy for Karen's attorneys would be, I'm not sure which case you're talking about now. The default judgment benefits the plaintiff. So if the plaintiffs in the O'Keefe versus Reed case got a default against Karen, that would be bad. The remedy for Karen would be a dismissal to dismiss the case because they're not providing discovery or they're doctoring evidence, not turning over evidence. In a criminal case, but I don't see that happening here. The Sandy Hook family's got a default against Alex Jones, who was the defendant. Lisa says they're trying to use this case to plant evidence that looks like Reed is leaking information in the hopes it will let them win their defamation case. They're trying to poison the judge. Thank you for your thoughts, Lisa. Bridget, thank you very much for gifting 5 memberships. Jackie, thanks for joining. Do as I say, not as I do seems to be Judge G's motto, says dancing in the pea patch. And Sue says, Judge Gildea might regret citing ethical issues as it might come back and bite him in the keister. Maddie fails to CC Turtle Boy's attorney. Ethical issue? Oh, that could be an oversight. That's not necessarily an ethical issue for Maddie, but remains to be seen. And South Boston Kev is here, and he says, guys, don't let me oversleep for my deposition tomorrow. Oh, so Higgins' deposition is supposed to be tomorrow, and today was supposed to be Tully. I'm dying to know if Tully is happening or happened, because it's already 5:50. It would be done by now. Cheney says, no one doctor can section an individual. A multidisciplinary team is required, except, of course, in Karen's case, you do God's work, Melanie. Admiration and love from Ireland. Thank you. Thank you so much, Jeannie. All right, let's take a look at the the demands that the O'Keefes have made for Karen's medical records and her medications. It'd be interesting to see what happens with this. Oops, cancel. All right, that can go. 1 second. All right, this is the plaintiff O'Keefe's motion to compel Karen Reed to further answer interrogatories. And here's what they're complaining about. They want further answers to these questions. These are the answers that Karen gave in response to the questions, okay? This first question is, she has objections to 3. Number 1, for a 2-year period before January 29th, 2022 through present, please identify your primary care physician, including for each such physician, the date range, which physician served as your primary care provider. This is her answer. Objection. Ms. Reed's medical health is not an issue in this action, and therefore she objects to this interrogatory on the grounds that 1, it seeks information that's irrelevant and immaterial to the facts, issues, claims, and defenses in this action, and therefore outside the scope of discovery pursuant to Rule 26. 2, it seeks medical information that is private in nature and is protected by the state and federal law. 3, it is solely interposed for an improper and unwarranted fishing expedition that is intended to harass and burden her by seeking irrelevant information about which she has a reasonable expectation of privacy. And ordinarily, that is true. A defendant in a lawsuit does not put their medical condition at issue. That is completely different in the case of the plaintiffs, because the plaintiffs are claiming that they have been emotionally distressed by what Karen Reed did by not only killing their son or brother with a car, but also by spreading this false narrative to the public, which caused them emotional distress. So all of their medical records are discoverable, but Karen Reed does not put her medical information at issue here. They're suing her for a car accident that didn't happen, and for this false narrative that they say that she spread. Okay, I don't see that puts her medical condition at issue, but O'Keefe's are going to tell us why they think she should. She also objected to this interrogatory number 2. For each and every medication, whether prescription or over the counter that you were taking had been prescribed or had access to on January 28th and 29th, 2022, please answer the name of the medication, the dosage and frequency of use, the date such medications were first prescribed or obtained by you, the condition or purpose for which such medications were prescribed or used, identify the prescribing physician or healthcare provider of the prescription, identify the pharmacy where the medication was filled, if prescription, and whether you took said medications on January 28th and 29th of 2022. If so, the times and dosages taken. Karen Reed objected to that and said, Ms. Reed's medical health is not an issue in this action, and therefore she objects to this interrogatory on the grounds that it seeks information that is irrelevant and immaterial to the facts, issues, claims, and defenses in this action, and therefore outside the scope of discovery, that it seeks for private medical information protected by state and federal law, and it is solely interposed for an improper and unwarranted fishing expedition that is intended to harass and burden her by seeking irrelevant information about which she has a reasonable expectation of privacy. Interrogatory number 3. This is what they want to know. with regard to her financial records. For each purchase or transaction you made on January 28th or 29th, please answer the purchase/transaction, identify the financial institution, credit card company, third-party vendor, or app you use to satisfy the purchase or process the transaction. For example, bank account, financial account, credit card account, debit card account, and or payment platform, including but not limited to checking accounts, savings accounts, credit cards, debit cards, and any third-party payment vendors or services, the type of account, the account number, the name in which the account is or was held, the address of the financial institution or vendor, and give the approximate date and time for each purchase or transaction. Yeah. Victory AK says, this is what a tyrannical state looks like. Welcome to 2026. Here you go. Objection. This is her objection. Ms. Reed objects to this interrogatory as overbroad, unduly burdensome, and seeking information that is irrelevant and immaterial to the facts, issues, claims, and defenses in this action, and therefore outside the scope of discovery under the rules. She also objects to this interrogatory to the extent it seeks information subject to the attorney-client privilege, work product doctrine, or any other recognized privilege or protection. Maybe she paid maybe she paid David Unetti that day or some other attorney, right? Oh, please. Subject to and without waiving these objections and based on her current knowledge and recollection, Ms. Reed states that she had depository or credit accounts with the following banks and credit card companies during the time listed in this interrogatory: Bank of America and Barclays. So she's just telling them where her accounts are. And there you go. She signed it April 30th of 2026. The attorneys for O'Keefe didn't like it, and they want her to give them more information. Take this down, put this up. Karen's team, of course, opposed this. Here's their opposition. Trying to get the judge to order Karen to answer these questions in writing. But meanwhile, they already have deposed her. Her deposition, her first part was on June 24th. This was eventually filed July 2nd, because remember, you need the whole package to file it with the court. So this here is defendant Karen Reed's opposition to the motion to compel further answers to the interrogatories, the 3 questions that we just looked at. As we know, they want Karen's primary care physician for the 2-year period prior to January 29th, 22, description for all of her medications, etc. We just read it. We don't have to read it again. Dosages and her financial records that reflect the purchases and transactions she made on January 28th and 29th. Reed's medical information is irrelevant to plaintiff's claims or Reed's defenses and is private and protected. These interrogatories amount to an improper fishing expedition targeting information for some purpose other than litigating the claims in this case. Additionally, Reed has already produced documents sufficient to provide the relevant financial information the motion seeks, including her credit card and bank statements that show her purchases and transactions on January 28th and 29th. Like she already gave it to him. In addition to not just the primary doctor info for 24 months, a description of all her medications, they also want the details as to the diagnosis for which each such medication was prescribed to her. Plaintiffs state that armed with the identity of her primary care physician, they will seek her medical records. Reed objected because the information sought is irrelevant and confidential. The SJC has recognized a legislatively created policy favoring the confidentiality of medical records, despite the fact that Massachusetts does not recognize an absolute privilege barring discovery of medical information in civil litigation. In addition, Massachusetts general law states a person shall have a right against unreasonable, substantial, or serious interference with his privacy. And there are few sources of information, if any, that are more private than a person's medical information, including the medications she takes and the reasons for the medication. Plaintiff has not shown the need for this information, any need for this information, much less a need that would overcome the policy described by the SJC. In fact, Reed's health, let alone her health history from January 20th through January 2024, is irrelevant to this case and therefore outside the scope of Rule 26. Plaintiff contends that this private information is discoverable to help improve her level of intoxication and any additional factors that may have enhanced her impairment. They failed to explain how her detailed medical history would help them establish Reed's level of intoxication or cite any law to support their contentions. Instead, they rely on an apparent statement by Reed's father, where he's alleged to have voiced concerns to a 911 operator that his daughter, quote, has a boatload of pills because of her condition, and she could take an overdose, end quote. A literal reading of Mr. Reed's alleged statement is that he was worried she could overdose because of the traumatic stress of learning her boyfriend was dead, not because she was taking a boatload of pills that impaired her driving abilities. Through 2 lengthy criminal trials and discovery in this case, there has been no allegation that Reed was impaired by prescription medication on the night or early morning that John O'Keefe died. Also, all you got to prove for wrongful death is that Karen Reed killed John with her car. Okay, that's it. Good luck. 18-wheeled alligator crate, who does in fact have a Belgian Malinois who sleeps like 14 minutes a day, that he takes with him in his truck. If they want her medical history, just get it from Proctor's texts. Well done. Well done. Further, at the end of her second criminal trial, Reed was convicted for operating under the influence of alcohol. Right, they can use that conviction. Although she disputed that finding in that case, her toxicology results, including her blood alcohol level during the pertinent time frame, are a matter of public record. Thus, there's no need for plaintiffs to delve into her private medical history in order to pursue their civil claims. Such discovery is not reasonably calculated to lead to the discovery of admissible evidence, and the resultant invasion of Reed's core privacy interests would be disproportionate to the needs of the case. For this reason, plaintiff's motion to compel should be denied. XO, Karen's team, and then, of course, they reply. And they're going to try and give some more reasons why they think that they really, really, really should be entitled to get this stuff. No tampering, LOL. Oh, yes, the caption is true. The caption's true. We went over that first, Mad Marcia. You're going to be mad about it, though. Maybe you want to watch what we got here and then rewind. Yes, it is true. Judge Gildea was provided Aidan Kearney's tweet by Proctor's attorney, Hamill. It's true. It's true. And here's the O'Keefe's reply to Karen Reed's opposition. Here you go. Defendant's medical information is directly relevant to the plaintiff's claims. Defendant Reed fundamentally mischaracterizes the nature of this litigation when she argues that her medical information is irrelevant. This is not a case where plaintiffs are seeking unrelated medical history as a fishing expedition. Rather, defendant Reed's level of impairment and the factors contributing to that impairment are at the center of plaintiff's claims. Defendant's attempt to shield this information is unfounded, right? If they can't prove a car crash, her medical records are irrelevant. Thank you, Livid Wiz. Thank you. She's been convicted of the drunk driving charge. So that may come in as a matter of law because it's a conviction. I don't think her prescription records have anything to do with this case, and I don't think they're going to be entitled to them, but who the hell knows? Because Judge Gildea. Technically, hold on a second. I got to address this. Technically, the ex post sent to the judge was not altered. It was misrepresented. No, it was sent to the judge with a 2:52 p.m. timestamp. That is altered because the East Coast timestamp on it was 10:52. So technically, it was altered. Someone altered it to have that timestamp to send it to Proctor's attorney so that he could send it to the judge. So I disagree. I'm not saying that Proctor's attorney did it. I'm saying maybe somebody did it and sent it to him intentionally. That's my opinion, and I'm sticking to it. Medications can enhance alcohol impairment. It is well established certain prescription medications can significantly enhance impairment when combined with alcohol. But you know what's so funny about that is that nobody said Karen Read was trashed. Everyone at the bar, including the McCabes and the Alberts that were there at the waterfall, all said Karen Read appeared fine. She was fine. That's why, in my opinion, Proctor had to proctor James Sullivan's statement to say that Karen Read was toasted. Okay. It was UTC. If you didn't hear it, go back and watch it. Go back and watch it. We explained it all. We're done with that conversation. We're moving on to the next stuff. But it was UTC. We talked about it at length, and that's it. The judge should have vetted it, in my opinion. So again, right, exactly. This. The timestamp has been confirmed as being UTC time, which appears on tweets when you aren't logged in on a browser. Right. How did he get it? Okay, moving on. I'm not going to believe that this was an honest mistake. I'm just not right now, based on all the shenanigans that I've seen for the past 2.5 years in this case. Moving on. Defendant's argument that through 2 lengthy criminal trials and discovery in this case, there's been no allegation that Read was impaired by prescription medication is irrelevant. The absence of such allegation in prior proceedings does not preclude civil discovery in these matters. Plaintiffs are entitled to conduct independent discovery to develop evidence for their civil claims. Well, you know what? Before you took this case, Mr. Diller, you might have wanted to be certain that your evidence was going to prove a car accident, because now you're grasping at straws, wet paper straws. If you were so convinced that this was a slam dunk case for you as a plaintiff's attorney because you could prove a car accident, and that's why you took it, because you don't get paid until if and when the case settles. You can't all of a sudden now try and start grasping at wet paper straws to try and make a case. There was no accident. He says, specifically, plaintiffs must prove defendant Read's intoxication at relevant times on January 28th and 29th, 2020. Why? You have to prove a car accident, sir. You got to prove a car accident. Because if she hit John O'Keefe with a car, whether she was intoxicated or not, or on drugs or not, or on medication or not, you have to prove that she hit him. And another problem you're going to have with insurance coverage, potentially, I know we have a lot of insurance adjusters in the chat. They could disclaim maybe, and then you wouldn't get any money. I don't know. Yeah, this argument fails. Everyone that night should have been gotten an OUI, not just Karen. No, it's not. It's that argument fails. It's not. Karen Read's the only one who was charged with anything. So that's just an argument. That's just a non-starter. You know what I'm saying? It doesn't matter that everyone else was drinking. It's just not the way it is. There's no field sobriety test. Right, exactly. She could, exactly. But it's difficult to understand how defendant Read disputes relevancy here when her own criminal defense attorney cross-examined forensic scientist Hannah Knowles of the MSP Crime Lab during her retrial. During this cross-examination, Mr. Yannetti elicited the following affirmative responses. To calculate a precise conversion rate, you'd first need to know precisely the amount of water in somebody's blood There are a number of factors that influence the amount of water in somebody's blood. Medications potentially affect the amount of water in somebody's blood. Oh my God. Oh my God. You know that calculation was bogus. You know that everything the crime lab did was bogus. The extrapolation was bogus. And now, and because you also don't know the time of her last drink, you're going to try and manufacture some evidence? No. She was never charged with drunk driving at all. It came on as an add-on charge on the jury instruction and on the verdict sheet, because her attorneys asked for it. She was never charged. The blood test was not taken on the night at the hospital. The blood was not taken until something like 9 a.m. And they allege that she hit him with her car at 12:45 or sometime earlier. They keep changing their timeline, so it's hard to know. And they didn't take whole blood. They took plasma. There's a lot of problems with that. A lot of problems with it. This testimony, elicited by defendant Reed's own counsel, confirms that medications are directly relevant to blood alcohol concentration calculations. Plaintiffs are entitled to discover what medications defendant Reed was taking to evaluate their potential impact on BAC evidence in this case. I completely disagree because it doesn't matter. You just have to prove a car accident. And you can't do that. 2, defendant Reed's father's statements create a factual basis for inquiry. Beyond the general relevance of medical information, defendant's father's own words provide a specific factual basis for this discovery. Defendant attempts to dismiss her father's 911 statement by arguing that a literal reading of Mr. Reed's alleged statement is that he was worried she could overdose because of the traumatic stress of learning her boyfriend was dead, not because she was taking a boatload of pills that impaired her driving abilities. This argument misses the point entirely. Plaintiffs do not seek discovery based on why Mr. Reed expressed concern about his daughter. The reason for his concern is immaterial to this inquiry. What matters is what the statement reveals, that defendant had immediate access to a substantial quantity of prescription medications, quote, a boatload of pills on the morning of January 29th of 2022. I don't remember if we ever heard a 911 call from Mr. Reed. There was some questions about that, and that is the reason why they decided to section her based on that phone call. But I don't know if that tape has ever been. I can't recall right now, but everyone seems to agree, so I'm just gonna leave it for now. This statement opens the door to plaintiffs' critical questions. What medications comprise this boatload of pills? Did Karen Reed have access to those medications on January 28th and 29th, 2022? Were any of these medications ingested on January 28th, 29th, 2022? Defendant Reed's attempt to reframe her father's statements as post-traumatic grief underscores the point. Regardless of the context, the underlying facts remain that defendant Reed possessed enough medication to cause alarm. That fact alone justifies discovery. I don't think so. I don't think her father's alarm that she may take her own life entitles you to her prescriptions. But again, we're in Massachusetts. Yes, we heard that call. Okay. It was a long, long, long time ago. B, Massachusetts law does not support blanket objections. They're saying that medical records are not absolutely privileged. And because her medical conditions and medications are reasonably calculated to lead to the discovery of admissible evidence, because various medical conditions directly impact blood alcohol concentration test results, certain pre-existing conditions may affect a body's fluid balance, metabolism, fluid, and liver processing, thereby skewing both BAC ratings and alcohol processing rates. Again, all you gotta do is prove a car accident, dude. That's it. Similarly, the request for defendant's primary care physician is routine information needed to subpoena records. No, you're not getting them. You're not getting them. Moving on. Defendant's OUI conviction supports discovery. Finally, defendant argues because she was convicted of operating under the influence of alcohol and her toxicology results, including her BAC level, blood alcohol level during the pertinent time frame, are a matter of public record, plaintiffs have no need for additional discovery. This argument is backwards. Defendant's conviction for OUI confirms that her impairment on January 28th to 29th, 2022 is relevant and at issue in this case. Right. Angelique, it's all BS because John O'Keefe was not hit by a car. Right? Right. Plaintiffs are entitled to understand the full scope of that impairment, including any medications that may have contributed to or enhanced her alcohol-induced impairment. The simple fact that her blood alcohol level is known does not answer the question of whether prescription medications compounded that impairment or it affected the accuracy of BAC calculations. D, she didn't hit him, so it doesn't matter. Thanks, Megan. That was Queen Dr. Laposada said that famously on the stand. She didn't hit him, so it doesn't matter. Defendant's redacted bank statements production is insufficient. Defendant claims she's already produced documents sufficient to provide the relevant financial information sought by the plaintiffs. This characterization is misleading. While defendant has produced bank statements for January 28th and 29th of 2022, those productions contain significant redactions that obscure relevant information requested in interrogatory number 3. What defendant Reed did and what she consumed on January 28th or 29th is reasonably calculated to lead to the discovery of admissible evidence. Okay. Do you think that she picked up the bar tab? Even if she picked up the bar tab, she could have bought drinks for all those other people at the waterfall. Somebody else could have picked up bar tabs for her. Like, is that what they're trying to get at, do you think? Because that was my first thought. But then they say that we want to know where defendant Reed was and what she did during the relevant times on those days. This information is critical to establishing the full timeline of events. Well, didn't Jen McCabe provide you with the timeline? Doesn't Peggy O'Keefe have the timeline? Because wasn't it her suggestion that Kerry Roberts and Jen McCabe make a timeline and make Denise Galvin, her sister, the scrivener? Wasn't that Peggy's idea? I'm going to assume Peggy's got the timeline. That's something that I would request in discovery. The timeline requested by Peggy O'Keefe. Because we've never seen it, and I'm really interested in the timeline. Plaintiffs are entitled to unredacted financial records in order to subpoena the relevant financial institution. Oh, really? Now you want to get into her accounts at Barclays? This document production does not satisfy defendant Reed's discovery obligations in relation to interrogatory number 3. I don't know how many interrogatories they served altogether, but if she's only objecting to 3 of them, that's not a lot. Conclusion. For the foregoing reasons, plaintiffs respectfully request that this court grant plaintiffs motion to compel and order defendant Reed to provide complete answers to interrogatories number 1, 2, and 3 within 14 days. XOXO. Mark Diller and Company. And this actually, I think this just was made public yesterday, maybe. Thoughts, questions, comments, concerns. So much to digest, so much to say. Back to the chat. I stand with Mel. Thanks for your 10. I immediately was concerned for Turtle Boy because even though proven incorrect and not a leak, it is the fact that the judge automatically believed Turtle Boy was in the wrong, right? Which is why I don't think that he can sit on any of Turtle Boy's cases because he's shown a bias. So in reality, it could be a good thing. Craftastical, Paul O'Keefe emailing Deitch is telling. I wonder if these comms could undermine his belief that Karen Reed is responsible if he's questioning her guilt. I don't know, but I've got that queued up actually too. So if you want to watch a portion of the interview with Adam Deitch where he talks about Paul O'Keefe. Oh, thanks, Em, but I don't want to play it. We can do that. We can do that. Can you please check why I can't send green level super chats? Jeannie, I can't tell you right now while I'm on stream, but if you email me at the email address linked below in the show notes with a link to your channel, it has to be a link to your channel. I can look into it. South Boston Kev says, Haas many fireballs before my deposition. I don't know. Don't you like JMO and Jinja? Isn't that your drink of choice? Think he's going to show up? I stand with Mel, give it 5 memberships because she's amazing. She's amazing. Yellow Ledbetter said the judge himself should be paying for all 32 lawyers' fees. Well, it was 32 people who signed affidavits, including the parties. So not all of them were attorneys and not all of them showed up. Some got a special dispensation to not be there. But I hear what you're saying. Flights, etc., for that 48-hour notice, nonsensical court date. Thank you, Melanie, as always. Thank you, as always, for being here. Foxy Wolf says, I wonder if ARCA will be brought in by AJ for this trial. Yes, they've already done the work. Who better than them to show that there was no car accident? They've already done the work. You don't have to hire a whole new expert, right? And have them start anew with blue paint and stuff. You can just hire the guys who've done it already. Not the blue paint guys. That's Welcher. Do you think the O'Keefes will call Welcher in to prove there was a car accident? That would be funny. Or do you think they'll call Trooper Paul? Thanks, Foxy Wolf. And look at 18-wheeled Maligator Crate coming in here and gifted 5 memberships. You know why? Because he's amazing. Amazing. Susan, thank you for your very generous 100 by Venmo. She just says, thank you. You're amazing. You're amazing. All right, let's watch a little bit of the interview, the Adam Deitch interview with Kristina Rex. What do you say? Oh, I have one other thing for you. Wait, hold on, because this is really good. Let me just see how I'm going to pull this up. It's a side-by-side comparison of Lindsay Gaetani's subpoena and James Sullivan's subpoena. Are you ready for it? I made this graphic myself. You're going to love it. Hold on. Let me take this down. Let me pull this up. Where is it? Oh, where did I go? Here I am. I'm here. Okay. So this is interesting because, yeah, I know you sent it. I don't want to play it, though. I don't want to play it, Emily, if it's heartbreaking. I don't need any more hearts broken today. I can't do it. I can't have any more heartbreak today. All right. So you may recall Lindsay Gaetani was served by Tully with a subpoena to allegedly testify in front of a grand jury all the way back in December of 2023. Coincidentally, James Sullivan was also served with a subpoena to prep for trial in March of 2024. Let's compare the subpoenas side by side, shall we? Many people think that the subpoena served on Lindsay Gaetani was a bump, that it wasn't real, that it was used to incarcerate Aidan Kearney because they knew or orchestrated that the second Lindsay Gaetani got a subpoena to come testify in front of a grand jury, that she would call Aidan, and that would start the wheels in motion to get him to violate his bail conditions, right? Hold on. Looks like there's been some new filings since we got on, so we'll look at that afterwards. Okay. Let us take a look. Lindsay Gaetani tweeted, this morning. She says, I've been thinking a bit about Greg Connor lately. As previously mentioned by others, his name was on the subpoena that I received on December 22nd, 2023. which required me to testify before the grand jury. After recently seeing witness James Sullivan post his subpoena, I went digging for the original copy of my own. Some things stood out to me. 1, where my subpoena states, please report to the Special Assistant District Attorney. There's a blank box with no name. So right here. You might have to enlarge it on your screen because I can't really enlarge it here because of the way I pulled it up, which, you know, maybe I'm going to pull it up, but let me pull it up a different way so that I can enlarge it because I know it's really hard to read. Let's take that down. Let's put it up a different way. Where is it? Okay. All right. You don't trust Lindsay Gaetani? Well, we've all seen this. This subpoena is not new. We've seen this a million times. She says, after recently seeing witness James Sullivan post his subpoena, I went digging for the original. Where my subpoena states, please report to Special District Attorney. There's a blank box with no name, right? So it says right here, please report to Special District Attorney, Assistant District, it's blank. Okay. If you look at, this is Sullivan's subpoena. It says report to District Attorney Adam Lally. Okay. And has Adam Lally's signature. See, Adam Lally's signature down here. That's my cursor on your screen, not a fly. And then on Lindsay's subpoena, there's no signature. There should be a signature right here in the box that is blank. Michael Marcy's signature appears on hers, allegedly, as it appears also on him. This was a cut and paste job. Okay. This piece is interesting because Ken Mello stood strong in his claim that he had no idea that corrupt Brian Tully was going to blindside me with a subpoena. 2, the witness on my subpoena is Michael Ricciuti, Esquire, who just so happened to be appointed as the Chief Justice of the Superior Court on the same exact day that he was the witness to my subpoena. Oh, interesting. Where's Ricciuti? Hold on. Witness, Michael Ricciuti, Esquire, at Dedham, December 22nd, 2023. Sullivan says, witness, Judith Fabricant, Esquire, at Dedham, March 27th, 2024. She says, this could be nothing, but it's interesting to point out nonetheless. 3, on Mr. Sullivan's subpoena, it states that any correspondence should be sent to Steve Nelson, the victim witness advocate. Okay, where's that? Okay, right here. Any correspondence should be sent to Steve Nelson, 45 Shawmut Road, Canton, Mass. Remember, he was the victim witness advocate. This would have been for trial number 1 in April of 2024. On my subpoena, it says any correspondence should be sent to, oh, look at that, Gregory P. Connor, 45 Shawmut Road, Canton, Mass. No, I whited that out. That's her address. I wanted to be respectful of her and take her address off of there, which I did. She goes on to say, but why would any correspondence be sent to Greg Connor when the entire reason that a special prosecutor was assigned to the Dr. Turtleboy cases in the first place was because the Norfolk County District Attorney's Office was conflicted out. That's right. Ken Mello would have been the special prosecutor. And then she tags Greg Connor and says, Greg Connor, could you enlighten us? This is the subpoena that James Sullivan, he wants to burn the house down, received to appear for trial. April 16th, 2024, James Sullivan accompanied or was at CF McCarthy's on the evening of January 28th, 2024, where he spoke to Karen Reed and John O'Keefe. He's in video. He was called to testify at the trial. When he went to be prepped for trial, he met with Adam Lally and Tully. When they questioned him about Michael Proctor's statement, Michael Proctor says in his statement that James Sullivan told them that Karen Reed was toasted. He said, I never said that. I never said she was toasted. They did not call him to testify at trial, and they did not tell Karen Reed's defense team that his witness statement was incorrect. Can you say Brady? Can you say Brady? Yes. Kelly says, you mean Turtle Boy's lawyer can find out if the grand jury subpoena is authentic? Isn't there a date of grand jury sessions? Yes. So she was scheduled to come in December 27th, 2020. Well, it says 22223, which is interesting. But the thing is, one grand jury had already been completed and the other grand jury had not been convened yet. So many people think this was fake. Yep. Lally also did mention James Sullivan in his opening too. So there's that. Yeah, Lindsay's subpoena is for grand jury and Sullivan's is for regular court. That's true. Well, let's see. It says for 2 grand jury. And this says to Superior Court. However, Greg Conner should be nowhere near this because the Commonwealth was recused. I mean, the district attorney's office was recused from anything having to do with Aidan Kearney. And it says here, in Ray, the investigation into Canton witness intimidation. So obviously it was a grand jury allegedly for Aidan Kearney. Still shouldn't be. Greg Conner's name should not be on there. I think Ken Mello did say that they may have to come back another day, but there was no grand jury held on December 27th, 2020, 22223, says Glamasuz. So there's that. No, James Sullivan's subpoena was legit. I'm going to put this on your screen one more time side by side so that you can, if you want to, you can screenshot this and then come back to it later. And I take that down. James Sullivan's was real because he got it and he went in to meet with Adam Lally to prep for his trial testimony. But Adam Lally didn't meet to prep him until after openings. They didn't call him. And he's blasting it out there everywhere. Everywhere. So I'm sure some sleuths out there will get some more ways that perhaps Lindsay Gaetani's was fake. And so there's that. These are both summonses. These are summonses, not subpoenas. Well, it's a summons. What do you mean? All right, so it's a summons to appear for court. So summons. I'm using the term interchangeably. They were personally served with it. They're commanded to appear. Who says toasted? I don't know. 80s. People in the 80s, maybe. Boomer? I don't know. Gen X? I'm Gen X. I don't remember ever saying toasted. What's Proctor? A millennial? I don't know. Okay, so there's that. I thought it was interesting. I thought you'd like to hear about it. But now let's go to the Norfolk DA candidate, Adam Deitch's interview with Kristina Rex of CBS Boston that dropped yesterday. Just yesterday? Oy. All right, let's go here. Kristina Rex, to her credit, did interview everybody who's running for Norfolk County DA. So I should give everybody equal time.
I've asked everybody this question, so I'll ask you now. If you had been the DA in January of 2022 when Officer O'Keefe's body was found on Brian Albert's front lawn in Canton, would you have sought to charge Karen Reed, and what charges would you have sought?
Yeah, so I'm going to answer that question only based on information that has become public.
Right, and I should point out that you know more than the public does. So let's go based on public information.
Yeah, and just to step back, it's been publicly reported that I was the lead assistant U.S. attorney in the federal investigation into the death of John O'Keefe and the ensuing state investigation and prosecution of Karen Reed. And because of Justice Department policy, I can't talk about anything that is still a part of that investigation that hasn't been made public. What I can say, though,
He knows a lot more than we do about what happened with the federal investigation. Right? Yes, he does.
Is this. That case, to be sure, brought to light deficiencies in this DA's office that are part of the reason why I'm running. And part of the reason the public is so angry about what's been going on in this DA's office. You asked, what would I have charged on January 29th, 2022? Well, first of all, I wouldn't have drawn any conclusions on January 29th, 2022. I would have ensured that investigative steps were taken. You and I are not trained investigators, unless, Kristina, you are.
I'm not.
And that's it.
No.
But there are things that you and I would have done when John O'Keefe's body was found that were never done by the state police. You and I would have secured the crime scene. You and I would have asked to search the house. In this DA's office that are part of the reason why I'm running. And part of the reason the public is so...
I don't know why that's just freaked out. Hold on. To jump forward?
I was the lead assistant U.S. attorney.
Public information.
The investigation of Karen Reed. And because of Justice Department policy, I can't talk about. And I can say, though, is this. That case, to be sure, brought to light deficiencies in this DA's office that are part of the reason why I'm running. And part of the reason the public is so angry about what's been going on in this DA's office. You asked, what would I have charged on January 29th, 2022? Well, first of all, I wouldn't have drawn any conclusions on January 29th, 2022. I would have ensured that investigative steps were taken. You and I are not trained investigators, unless, Kristina, you are.
I'm not.
And that's it.
No.
But there are things that you and I would have done when John O'Keefe's body was found that were never done by the state police. You and I would have secured the crime scene. You and I would have asked to search the house. You and I would have, we would have conducted interviews of people who were in the house. And so number one, I would have completed an investigation before charging anyone with anything. And I think, I can't comment on specific aspects of the evidence, but I think at the end of the day, the jury got it right based on the evidence that was presented at trial. And you know more than most because you were there. But there were witnesses in the trial who I found very credible. Dr. Wolf and Dr. Rentschler, who were working for an entity called ARCA.
Who had been hired by the feds.
Who it was reported were
initially.
hired by the federal government as part of its investigation. They are PhDs whose opinions are unassailable. And they concluded, as you know, and as many folks know, that the taillight could not have broken on John O'Keefe's body. And I think that's pretty telling when you compare that evidence to the similar evidence presented by the state with Trooper Paul at the first trial and the blue paint expert at the second trial, who, by the way, cost taxpayers $400,000.
Oh, excellent point. Pointing out the blue paint and the $400K that they paid him to come to that, right? Wow.
I'm going to ask you again because I've tried to pin everyone down on this, which is knowing what the public knows, I'll say, not knowing what you know. Do you think Karen Reed was the person to charge in that case?
For driving while intoxicated, yes.
For the death of John O'Keefe?
I think the jury got it right.
Okay.
He hasn't said the investigation and the FBI has closed their file. He didn't say that.
Do you believe that case at the state level?
Sorry, by the way,
keep going.
We would have saved more than $400,000 if she had been charged with driving while intoxicated. She would have, it's not just $400,000. It was $566,000 of taxpayer money to hire an outside prosecutor to try the second case, to do a job that we all assumed the DA's office should be doing in the first place. It's the cost of all of the other ADAs and legal staff at the DA's office. It's the cost of the court time and court staff and police details to provide security at the courthouse. It's the busing of the jurors to the courthouse every day. It's probably more than $2 million of taxpayer money to try a case that DA Morrissey appears to have been obsessed with.
That's your belief of
Morrissey was obsessed with this case. Tell us everything.
Why he kind of dug his heels in and did that retrial and whatnot.
In the end, I don't think I have said this to a reporter, but I talk about this when I'm asked, when was the first time it occurred to you to run? And the first moment it occurred to me, I was paying a lot of attention, obviously, to what was going on, especially during the first trial. And the first jury came back hung, and the judge declared a mistrial. And it felt like 30 minutes went by before District Attorney Morrissey put out a statement saying, we are proceeding with the same 3 charges and retrying the case again.
It was within hours, I can confirm, because I was there.
It felt
I was
instantaneous
still
to me.
on the courthouse steps when that statement came through, which means that it was within hours of the mistrial happening.
Right, that they wanted to retry her right away. They didn't take any time to even think about it and to think about what the community wants and the family wants. They were just right away. They could not lose this case.
So at that point, through the first trial, given the evidence that came in and the way the case was presented by the DA's office, the office and the attention, national attention, the office had become a national embarrassment. And so for that statement to come out moments after effectively the jury comes back hung, made me realize they don't even know there's a problem here.
That's right.
Not only could they not prove their case, not only were they embarrassed on national television, but they don't even realize it. And that's when I thought to myself, maybe I should do something about this. I thought, I have seen things that nobody else has seen. I am uniquely situated as a public corruption prosecutor. It did occur to me that
public corruption, he's going to expose it all. He's seen things no one else has seen. He specializes in public corruption. This is like the dream DA for the people in Norfolk.
I'm not married and don't have kids. And so I have the flexibility to leave my job. And I sold my place in Boston. I moved to Quincy to do this. Not everyone has the ability.
So you moved to Norfolk County just to do this? Because there's a residency requirement for anybody who doesn't
To
know
take
that.
office, yes.
Yes.
And I think, the reality is I was living in Boston, working at the U.S. Attorney's Office, loved my job, but saw what was going on here and realized somebody needs to do something about it. And I happen to be uniquely qualified in this moment, given everything that's happened. We're all in the greater Boston area. Norfolk County is a county of 750,000 people who effectively live right outside of Boston, who I consider my neighbors. And so I took the measures I needed to take to launch a campaign that's built to win. And that's why I'm doing this.
If you are elected to this position, do you think that there's more investigation at the state level warranted into the death of John O'Keefe?
So I think any case, including the death of John O'Keefe, where survivors, victims, and their family members do not have justice. And I think of the Sandra Birchmore case.
We're going to get to that next.
Literally every day. Any case where victims and their families don't have justice needs to be reevaluated. And when investigations haven't been completed, they need to be completed.
So I think, frankly, I don't know this because DA Morrissey has not answered requests for comment or interviews, but
of course he has.
I believe he would probably say this investigation is completed because they believe they have the right person. So you would say it's not.
I think there are investigative steps that were never taken by the DA's office or the state police. And I think, in addition, the DA's office jumped to a conclusion and they've been beating that drum ever since. And I think a lot about the O'Keefe family, who's been told the DA's party line ever since their loved one's body was found.
What do you mean by that?
I think that this case involved a rush to judgment. It involved shortcuts. It involved drawing conclusions about what happened before even collecting all the evidence. And I think the district attorney's office, in particular, DA Morrissey, has wedded himself to that conclusion at the cost of his credibility, at the cost of the credibility of his office. And that's what he's been telling the O'Keefe family ever since. And I think there needs to be, in every case, an honest dialogue with survivors, victims, and their families about the evidence, about what happened, and setting realistic expectations for what justice can look like.
Have you ever spoken with the O'Keefe family?
So I've exchanged emails with Paul O'Keefe, who's John O'Keefe's brother.
Yeah.
Okay. Adam Deitch and Paul O'Keefe have been emailing each other. Why? Is he going to tell us? Let's listen. If you're in Norfolk County, vote. September 1st is the primary. That's the date. September 1st, show up. Why was Paul O'Keefe emailing you? Who started it?
And we haven't met in person, but we've exchanged emails.
Do you anticipate you would meet with him?
I told him I would, absolutely. And I hope that certainly as DA, I think one thing that we can do differently is shine a light on the actual evidence in the case. And my hope is to have an ongoing dialogue, not just with the O'Keefe family, but with families of victims in other cases. I think I've become a repository for people who haven't gotten justice in Norfolk County. And I guess we'll get to the Sandra Birchmore case, but I'll preview.
You're a repository for people who haven't gotten justice in Norfolk County. Everyone's reaching out to you. You and Turtle Boy, both of you. Both of yous.
A few months ago, members of Sandra Birchmore's family endorsed me in this race, which is the most humbling thing that's happened in this race. It's the biggest honor of this race for me. And they're an example of a family that has been wronged by the DA's office. And it's sort of on another planet compared to the Karen Reed case, because you have another investigation that was never completed by the State Police Detective Unit, by the supervisors who were working with them at the DA's office. And the themes are remarkably similar. You've got a rush to judgment. You've got shortcuts taken. You've got a conclusion drawn before the evidence is collected. And in both cases, the U.S. Attorney's Office felt compelled to step in. And in that case, actually charge someone with Sandra Birchmore's murder.
Right.
Because the U.S. Attorney's Office and the FBI actually looked at the evidence in the case and completed an investigation and realized it's a murder, not a suicide.
We'll do Sandra Birchmore. We'll talk about her case now, and then I'll get back to a couple other questions I have on Karen Reed. But in the Sandra Birchmore case.
Okay, he's gonna pivot into Sandra. Do you want to keep watching this, or should I link it below so you can watch it? Have most of you watched it? Emily C says, yes, to be clear, September 1st is the primary, but the winner of the primary is going to be the DA. So you don't get another chance. You don't get another chance. Keep going. Okay, I'll keep going. Thanks, Sean.
Kind of the narrative that I've been informed of is that the medical examiner at the state level deemed it a suicide, and investigators in the DA's office, that's kind of where the investigation stopped. It's a suicide, therefore there's no one to charge. What would you have done differently if you had been in charge?
Yeah, so first of all, I would have completed the investigation.
You're saying it shouldn't have stopped there?
Absolutely not. And in fact, I'll get into a little bit more detail here, but I think number one, the investigative steps that the FBI and U.S. Attorney's Office took all could and should have been taken at the state level. And I think the people who are paying attention know this, but a lot of people don't realize about the back and forth that happens between investigators and medical examiners before a medical examiner makes a determination, because it's up to the investigators to communicate the circumstances, to communicate about some of the evidence.
Give context, right?
To give context for what happened.
Right, exactly. That's why Michael Proctor and Yuri Buchanan reached out to Irene Scorti-Bello at least 3 times to try and get her to change her manner of death for John O'Keefe from undetermined to homicide. Remember? Rookie move.
And I think, the implication that a member of law enforcement could have been involved in causing Sandra Birchmore's death and relationships and conflicts between members of law enforcement meant that the 2-tiered system of Michael Morrissey kicked in again. And so we have special treatment for Matthew Farwell, a determination of suicide, an incomplete investigation, and now a reliance on the feds to step in and do what the DA's office never did. And I'll go a step further. We have the public has seen credible accusations of what happened to Sandra before she was murdered. And it doesn't just stop with Matthew Farwell. And you know better than most, and because of the strength and fortitude of Sandra's family, who've been beating the drum on this for years, and the reporting of people like you and Laura Cromaldi at the Globe, the story has gotten the light of day, thank goodness. But she became a member of a police explorers program when she was in her teens, certainly years before she was 18. And there are these allegations that she was groomed and abused for years before she was ultimately murdered. Those are...
Oh yeah, this is, okay, if you've started to wander, come back. I've been saying this for a long time. These are state crimes too. Norfolk County has never filed charges against Matthew Farwell, and the difficulty at the federal level, it's much harder to convict Matthew Farwell for the federal murder crime than it would be for the state crime, and nobody has filed charges yet. And I think he's saying, when you elect me on September 1st, I will file charges against Matthew Farwell in state court because it's a much easier case. But let's listen to what he has to say. She's not the only one that was groomed and abused for years by the Police Explorers program. I've been told.
Groomed and abused for years before she was ultimately murdered.
Right, by multiple men. And it wasn't just Matthew Farwell. His twin brother, some other guy that worked with animal control, maybe Robert Devine.
Those are state crimes too. And so as DA, and certainly in consultation with the members of Sandra Birchmore's family, the family members of a victim of a murder, or it's an alleged murder. So I want to be careful with that. But certainly that's what the evidence shows. If there were other crimes committed, they need to be investigated. They need to be prosecuted. And we shouldn't be waiting for the U.S. Attorney's Office to step in every time a serious crime is committed in Norfolk County.
Do you mean by the other officers involved with Sandra Birchmore?
If they did what they're alleged to have done, those are state crimes that need to be investigated and prosecuted to the fullest extent of the law.
And then what about any state crimes, including murder, that Matthew Farwell might have committed? Is it worth moving forward on state charges at this point, now that the feds have taken this case?
Yeah, it's a great question. It's a question I get asked a lot. And I sometimes get bogged down in the nerdy details of the law here, but the federal case against Matthew Farwell is much more complicated than the state murder case would be.
Right, because isn't it like murder of a witness?
It's a version of an obstruction of justice statute federally, where you don't have to prove just that he killed her and that he intended to. You have to prove that the reason was to conceal evidence or testimony relating to a different crime. Whereas the murder case in the state is, did he kill her? Did he intend to? And it's a much more straightforward case. I don't know that I would trust this DA's office to complete that investigation and prosecute that case under its current leadership. But in the end, that's a case that could and should be brought as well. Obviously, if he's convicted of murder federally, we don't want to duplicate resources.
Right.
But there are other aspects of that investigation that need to be completed. I'll go a step farther, because the Karen Reed case got all kinds of attention, and the Sandra Birchmore case, because of her family and the reporting, got all kinds of attention. But those two cases raise what I think is actually the most terrifying question, which is because most defendants, most victims don't get the kind of attention that these two cases got. It raises the question, what else has been going on in Norfolk County that we don't even know about?
Yeah. And you're saying you don't know either, but you assume that maybe this is the tip of the iceberg?
I mean, these are the two cases that we know about, and what we see are nationally embarrassing deficiencies in the DA's office. The only logical conclusion is that when we start looking under the hood, we're going to find other problems. And I got a call 2 weeks ago.
He's going to look under the hood. He's going to look under the hood. You got a call 2 weeks ago. Tell me more.
Or had a call with a woman who lives in Norfolk County, whose young daughter was found dead about a year and a half ago, and she still doesn't have answers for that case. We get emails regularly, because I am this repository for people who have felt injustice from their DA's office, which is something no one should ever feel. And any case where there are serious questions needs to be looked at, needs to be reevaluated.
And it seems like you think that the buck stops at Michael Morrissey.
The buck stops with the DA. It'll certainly stop with me when I am district attorney. And for the past 16 years, the buck has stopped, short of or at Michael Morrissey.
I want to move on to one other future case before I circle back, which is Aidan Kearney, aka Turtle Boy. Is facing a number of witness intimidation charges in Norfolk County. There's a special prosecutor who's trying his case, and it's scheduled to go to trial right around the same time that a new DA would be taking over. Have you had conversations about that case? Have you thought about that case? And what would your approach be?
I think I'm not.
His trial is supposed to start in December. The new DA wouldn't take office until January. So it's kind of like, nice try, Kristina, but I don't think he's going to talk about pending cases.
I'm going to comment on specific pending cases. But I will say that I call into question the decision-making of this DA's office based on everything I've seen in cases that I've either investigated or looked at. And I think we need a fresh set of eyes on anything that this DA's office is doing. I'll also say the use of special prosecutors has gotten completely out of hand. We have an office that has a limited budget, most of which goes to salary.
Yes. Why did they need a special prosecutor? Why did they need Hank Brennan to come in and persecute Karen Reed for the second time? Why? There was no conflict. The only time you're supposed to use the special prosecutors is when there's a conflict. There was no conflict. He thinks it's out of control. Yeah, good. Talk about Hank Brennan. Ooh, this is a really good interview. I have it sped up a little bit just because it's kind of long.
And I think we need a fresh set of eyes on anything that this DA's office is doing. I'll also say the use of special prosecutors has gotten completely out of hand. We have an office that has a limited budget, most of which goes to salary. And we need to be handling cases with competence and trust and professionalism inside the DA's office. I get asked a lot about corruption in Norfolk County and police misconduct in Norfolk County. And one aspect of my policy agenda is establishing a first of its kind anti-corruption task force in Norfolk County, where we dedicate a senior assistant district attorney.
No wonder everyone is so flipping up in arms. Wait a minute. You're going to start an anti-corruption unit in Norfolk County? Do you see how all the rats are scurrying, and you see why all the trolls are out? They're scared as hell that he could get elected. And then the anti-corruption unit is going to come in. Listen again.
misconduct in Norfolk, which goes to salary. And we need to be handling cases with competence and trust and professionalism inside the DA's office. I get asked a lot about corruption in Norfolk County and police misconduct in Norfolk County. And one aspect of my policy agenda is establishing a first of its kind anti-corruption task force in Norfolk County, where we dedicate a senior assistant district attorney and one or more investigators to fielding complaints about public corruption and police misconduct.
You'd have to choose your investigators really carefully, and probably not from the MSP. So, there's that. Like, nobody trusts the investigators that have been assigned to that office for decades. You'd have to start fresh, clean house, get rid of all of them. Well, most of them have either retired, resigned, been rehomed. I mean, who's really left in the MSP assigned to Norfolk DA's office? Posse. He's like, I love this man. I really love this man.
Isolating those people so there isn't a conflict with their other cases and handling those cases in the professional way we've come to expect from the U.S. Attorney's Office, for example. I think we can do that kind of work. I think we can do it without as many special prosecutors, and I look forward to doing that.
So I'm taking that you would look at the case with a fresh set of eyes. Is that fair?
I would look at every case that we're doing with a fresh set of eyes, including that one.
Have you made any...
Including Aidan Kearney's.
Any promises or suggestions about what would happen to that case if you were to take it?
No, absolutely not.
Okay.
And I'm trying not to comment on specific cases until I get in there and read every page of every file.
Okay. I want to talk a little bit about your campaign contributions, because you are certainly someone who has raised.
All right, because so then she gets into campaign contributions and how Alan Jackson donated and the Reeds donated and so many of your donations are from people out of state. And he's like, yeah, well, people out of state are interested in the corruption in Norfolk County. So, he's raised more money, I think, than any other candidate. Spencer Pratt needs to help him with some commercials. Alexis D. Spencer Pratt didn't even make most of those commercials. It was made by people on the internet who just wanted to help him. And so we'll see. We'll see where that goes. An anti-corruption task force. No wonder they're freaking out, Anthony. They're freaking out. They're freaking out. There's no doubt they're freaking out. Oh, this is how much I love Law and Order. Mama She, did you hear? Mariska Hargitay is going to be hosting the Emmys. Yes. Mariska Hargitay, Olivia Benson is going to be hosting the Emmys, and I am so excited. I even have the Emmy nominations pulled up. So maybe in a few minutes or a little bit later, when we're done talking about all this BS, we can talk about the Emmy nominations. How about that? Emily C. made Greg Conner a commercial because she's amazing. Breaking news. Chris Maddie pulled out his wallet and paid the $355 on an emergency basis, to be admitted pro hoc vice for the wait, who's he coming in for? Wait, hold on a second. All right, well, this is a motion in the... Oh, he's coming in on an emergency basis for the $355 fee to represent Nicole Albert, Brian Albert, Colin Albert, Jennifer McCabe, Matt McCabe, Allie McCabe, Brian Higgins. They've made an emergency motion to have him admitted pro hoc vice in the O'Keefe versus Reed case, you see, because what had happened was there's going to be a hearing on Friday. Okay. This Friday, a hearing on the motions to compel all of those people to appear for their depositions. And so remember, they didn't want to pay the money because they said it was really expensive, but they did let him speak one day in court, even though he wasn't admitted on that particular case. Well, he had to pay the money, and he's going to appear. And the reason is that there was an order on the motion to compel all of them to appear for their depositions. So why don't we take a look at that one now? Let me just download it. And this is docket number 153. Docket number 153. This was just 153. Oops. This is the order on the motion to compel all those people to come to depositions because, they really just keep delaying it and everything, and they don't want to come. And so here's the order. That we did not have a chance to go over yet, but since we're here and everything sort of flows together, I love Mariska Hargitay. She's like my queen. I love her so much. I've auditioned for Law and Order several times. I'm going to get on one of these days. Organized crime too, except organized crime got canceled. And I really, really, really wanted to meet Chris Maloney. So another day. All right, let's look at this order to try and use our context clues to figure out why Chris Mattei would have to come in and argue this on Friday for the, what time is this conference supposed to be on Friday? Let's see. 2 p.m. Motion to compel. But here's the order on the motion to compel. So I guess Mattei's going to have some things to say about it. This came out yesterday. This is Judge Gildea's decision and order on defendant Karen Reed's motion to compel Nicole Albert and Brian Albert, Jennifer and Matthew McCabe, Allie McCabe, and Brian Higgins to attend depositions and produce documents pursuant to non-party subpoenas. That's paper number 141, and this is docket number 153. Let's see if Judge Gildea has any snarky comments. In this motion, docketed June 29th, 2026, Ms. Reed seeks an order requiring non-parties each to immediately provide 3 non-overlapping dates for deposition before July 17th and to provide responsive documents within 10 days. The filings reflect that non-party Allie McCabe was deposed on June 18th, 2026, and non-party Brian Higgins' deposition is scheduled for July 9th, which is tomorrow, 2026. So it is not clear why the request for dates includes them. Well, that is such a snark. Allie McCabe was already deposed, so why did you even include her in this? And I think they're probably assuming that Brian Higgins is going to have some really big excuse tonight, like some emergency of why he can't possibly be there tomorrow. Do you think all of these other people want Brian Higgins to testify? Do you think that it is improper and perhaps a conflict of interest for one law firm to be representing all these people? Because maybe their interests might be not so aligned. There are ways to waive conflicts of interest. You would have to have each and every one of these people sign a piece of paper saying you've been fully advised, that you've consulted with outside counsel, and you still want to be represented by all of them. Oh, I don't know. Is Mattei representing Higgins at tomorrow's deposition? I don't know. It wasn't me, but that's a good point. Could be. Could be, but I think he probably also wants to appear in court to argue this on Friday. So we'll see. As to the dispute, as to the remaining non-parties, I'm not sure what is more in conflict. One, the statement by Ms. Reed's counsel that he, quote, was and is willing to accommodate reasonable scheduling conflicts and concerns, with the failure to pick one of the many dates set forth in paragraph 8 of the affidavit of counsel for the non-parties. Yeah, they gave a very limited set of dates of when they would be able to make it at their own convenience. All of them were like mid to late July and August. And there's a hard stop allegedly on discovery for August 17th. Or two, the failure of counsel for the non-parties, as referenced in Ms. Reed's reply, to describe to the court the concerns about specific requests with the knowledge of the staunch position of counsel for Ms. Reed that the non-parties waived their right to object. The positions of both counsel simply result in unnecessary motion practice. Tell us again how you want everyone to come to you when they can't agree. And then tell us again how they shouldn't come to you when they can't agree. So it is ordered that 1, on or before Thursday, tomorrow, July 9th at 3 p.m., Ms. Reed's counsel shall notify counsel for the non-parties of his choice of the July deposition dates offered for each of the non-parties, because, they have none other to do. So the McCabes and the Alberts get their way, but it has to be in July. So they can't go into August. It has to be July, but it has to be at their convenience. That's why the judge wanted a list of all the depositions and the dates so that he would know when they were supposed to happen so that he can scream when they don't happen. Number 2, on or before Thursday, July 9th, that's tomorrow at 3 p.m., counsel for the non-parties shall notify Ms. Reed's counsel in writing of the concerns about specific requests not general objections. 3, counsel shall then confer to try and come to an agreement on the request that can be narrowed. Counsel should be able to narrow the request without the court stepping in. Previous orders and actions of the court on similar motions, see, for example, papers number 124 and 130, may provide counsel with some guidance. If counsel cannot come to an agreement as to narrowing the requests, they shall set forth their respective positions in a submission of not more than 1 page to be filed on or before 3 p.m. on July 13th, 2026, right? Because they're going to be back in court. No, not them. The defamation case is back in court on the 14th. What a mess this is. What a mess. XOXO. Judge Gildea. Let me say one more thing. Yeah, so that's today that was allowed. The pro hoc vice admission is allowed. Does he say in his petition that it's because he wants to? Oh, yeah. It says here, the reason it's being made on an emergency basis is because the deposition of non-party Brian Higgins scheduled for tomorrow. Oops. Scheduled for tomorrow, July 9th at 10 a.m. I had intended to defend Mr. Higgins' deposition, but I now have a conflict with a recently scheduled memorial service for a family member. Counsel for defendant Karen Reed has indicated that Ms. Reed will not consent to me defending Mr. Higgins' deposition unless I'm admitted to this in this action pro hoc vice. Well, yeah, pay the money, pay the $355. Accordingly, I bring this motion before the court on an emergency basis. Wherefore, the non-parties respectfully request that this court enter an order allowing Attorney Mattei to practice before this court pro hoc vice that was allowed today. The deposition is supposed to happen tomorrow, but he said he had intended on defending Higgins at his deposition, but now he's got a memorial service. So does that mean that he's not going to show up tomorrow? What do you think? What do you think? Kara says, every time I read Gildea, I see Gilead. That's why sometimes we have a special logo for that. It's the Handmaid's Tale rubber duck, because it just reminds us of the insanity that is Massachusetts courts. Here you go. There it is. It's a rubber duck dressed in a Handmaid's Tale costume. Back to the chat. Lisa Lott's Missing Robe says, Mel, please look into Nolan Xavier Wells, 18-year-old African-American from Mississippi who went to an island with his white friends and ended up dead and his friends left. Oh no. What island? Oh, reminds me of Natalie Holloway in Aruba. Penis Blue, MSP has answered seeing Mellencamp August 1 with mom. That's amazing. You bought the tickets. Congrats. Babe's mom, thank you for your super sticker. I stand with Mel, says, in my opinion, the judge cannot handle this. His actions that he believes is holding everyone accountable, and a no-nonsense judge is coming across as biased and having something to hide with not posting filings to the docket. Thank you for using the proper form of biased. Biased. Thank you for that. And for your 20. Craft Haskell, sorry, Melanie. I have ADHD. I have bad delivery. I mean no harm. I never meant to undermine what you say. Oh no, I love you. I didn't want anything that was in the chat that people might take as truth. And I don't even, to be honest with you, I don't even know what it is. So I don't even know what it is that you said. But when people put stuff in the chat that I happen to see, if it's like not factually correct, I just feel the need to correct it. I'm not holding anything against you. Thank you for your super chat. Strange Credulity, thanks for your 20, says, I hate the straw man argument that the FBI clears the Haas defendants, but fundamentally, that was clearly not the goal. And Adam Deitch is spelling it out. Is about corruption ongoing. That's right. You're right. Adam says, who thinks that Adam has reached out to Aidan? I don't think so. I don't think so. He's not allowed to talk about ongoing cases, and I don't think that he has. Do you think that he has? Thank you, Suze. Mima says, my childhood best friend met Mariska when she went to her show. Oh, she saw the Broadway show. She just finished her run. I'm green with envy. I know. I always tell everyone, if you go to a Broadway show, always go to the stage door. And because they do come out afterwards and they sign autographs and you get a picture. And Charissa is here and she gifted 5 memberships because she's amazing. She's amazing. I didn't see an answer from the MSP, so I'm not sure what your Venus Blue is talking about, but I think we should talk about the Emmy nominations because right now that's more interesting to me. And every single day, more stuff is going to come out, and every single day we're going to find more stuff. Here, thanks to Kyle Sharkey, since he sent it to me, I'm going to put these up on the screen for a minute. He sent me some copies, or some exemplar other subpoenas. So let us take a look because he does the Lord's work. He and Emily C. and Corey Hopkins, the Queen and Kings of the FOIA requests. So let me take that down, put this up. Okay. Oops. Here's some other subpoenas. The problem is that when I open them this way, I can't really zoom in on them. So or move them around. Looks like this one is for Brian Higgins. Oh, forget it. Brian Higgins of the ATF. And this was for March 4th of 2024. And it says correspondence should be sent to ADA Gordon Stanton in Rentham. Oh, this is for a different case. Wait, hang on. Yeah, this is for a different case. Okay, this is for Commonwealth versus in order to do this, I gotta download these. Hold on a minute. We have to do it a different way. All right. I'm sure people with far more time and better analytical skills can compare these and find all the things that are wrong. Let's get out of here. And let's look over here. And here's a subpoena that was sent to Brian Higgins of ATF in a different case, Massachusetts versus Tiago Oliveira. Please report to Assistant District Attorney Gordon Stanton. This was for March 4th, 2024. So I'm sure the eagle eyes will get on this, although there's no signature here on this one. So I don't know how this helps, but I'm sure Kyle will tell us all about it. V-Kind says, I'm from Illinois and I'm donating monthly to Adam Deitch's campaign. Norfolk County is overdue for a great TA. That's really nice of you. That's really nice of you. All right, thoughts, questions, comments, concerns. That's really nice of you. Hello, Tennessee. Hello, Tennessee. See if there's anything else in here that we need to cover. Any of the comments that I want to talk about? I don't know what this is. MSCP's response, emergency motion to extend deadline to comply with the June hold on. The June 26th court order, right? They were supposed to comply like by the 3rd. They didn't comply by the 3rd. So Karen Reed is like, they're supposed to comply. And now they're making an emergency motion to extend their deadline to comply with the court order. Remember, they were supposed to provide a privilege log by July 3rd. And so they're saying, about the 473 emails. And then apparently they're saying they never got the court order. And so I really want to please give me an extension to July 14th to comply with the court order. And Karen Reed did not respond because she's made a motion saying that they should automatically, it should be granted, and they're opposing it. So that's what that was. When somebody said they answered, I thought you meant they filed an answer to the complaint in the Bristol County action. So I was confused. They're claiming they never got it. Of course they never got it because they don't watch any of the hearings. They don't follow the docket. You know, they can run what they can't hide, said Anthony. That's what he said. Tracy says, has there been any updates on Colin being deposed? No, nothing. Does anybody else heard anything? Anybody else heard anything about it? I haven't. Just kind of like flew off the radar. Foxy Wolf says, I hope Deitch is elected, but I'm scared for him if he is. Just kicking the can. Kicking the can. What was the last thing that happened on that Colin Albert thing? Because now I'm conflating everything in my head, but I know that there's some wicked smart people who know all the details right at their fingertips. You know who you are. Hello, Ireland. Hi, Alexander. I'm very involved in Outlander right now because I've never watched it. And I'm only on season 1, like episode 7 or 8. That's in Scotland, I know, but I love it so much. I just watched the wedding episode last night. Yes, I just talked about Mariska hosting the Emmys. Should we look at the Emmy nominations? I think we should. And we can vote for who we like. And you can tell me what I should watch, and we can tell each other what to watch. Because a lot of interesting picks in here. A lot of interesting picks. Sarah says, I understand Turtle Boy has the right to say anything he wants, but in my opinion, he's disrupting these cases, making them into soap operas. The cases are bad enough as it is. Also, but the judge is showing his bias by just believing it, right? Without doing any due diligence. Listen, if he was my client, I would tell him to STFU. I've said that a million times. I would tell him to get off the internet. Stop talking. Stop talking. But it's how he makes his living. You know? After Outlander, watch the prequel, Blood of My Blood. Yeah, but it's like 8 seasons, right? I mean, I got to get there. I got to get to the end, right? I love all the seasons. I love the costumes. I love everything. I love it so much. Gildea put a hold on Colin Albert's deposition, just like he put a hold on Proctor's deposition. What is going on? Everyone loves Outlander. Favorite of all, I don't know how it escaped me. It's been going on since, like, I don't know, 2016. No, my YouTube plaque is not sliding out of its stand. It's just, because it's a little bit to the left. It's not going to fall. It's on a book. It's on several books underneath it, but it is crooked now that you mention it. So that'll bother me now. But I'm not going to do anything about it right now. All right, let's take a look. Yes, I did. Thanks, Kyle. I covered that earlier. And I think I pulled up a screenshot of your info because somebody sent it to me. Yeah, because state court, because Judge Gildea refused to adjourn the anti-SLAPP motion on the 14th. They just moved it to 10 o'clock from 2 o'clock. So Karen has filed a motion to adjourn the federal hearing, which is scheduled for the same day, until August 17th. And it gave the Haas, or all the defendants in that case, because she sued everybody. Oh, no, wait, is that the case that they, I don't know. Yeah, the case they removed to federal court. So she's the plaintiff, they're the defendants. And Judge Casper is giving them until tomorrow at noon to reply. Okay. So there's that. Too many things happening all at once. No, that's okay, Kyle, because there's a lot of people that tuned in late, so that's cool. Oh, thank you, Anon. Thank you, Anon, for your Venmo. It is my pleasure. It is my pleasure to help you, distract you from real life. Sherilyn, thank you so much. Says, when you're on, I feel lively again. Thank you. Some people find me really annoying and really loud and really, passionate, and it bothers them. I don't know. If you don't feel passion for something in your life, then I just feel very, very, very sad for you. Like if your whole life is spent on social media and Reddit and Twitter, just like saying angry things all day long and hateful things about people, then you have a very, very, very sad life. You should really try and fight for something. Try and find passion in something. And that's just sad. It's just sad. Don't you think? All right, keep talking to each other in the chat. But right now, produce documents, but no can file another. Yeah, right, without prejudice. Yeah, I know you guys sent me the reply, but I just read it to you. I just read it to you. So I don't have to pull it up on the screen and go through all that trouble again, do I? No, I think we're good. I think everything else I've talked about, but I just didn't pull it up. Oh, here's something. Well, what is this? Let's see. TIFF. Jennifer McCabe versus Karen Reed. So this is in the defamation case. Judge Gildea filed an order that says pleadings relative to the motions to dismiss scheduled for hearing next week were e-filed yesterday and today and are under review by the clerk's office. Okay, guess what we're doing tomorrow? Because remember, we don't get to see the motions to dismiss made by Karen Reed and Aidan Kearney until the whole package is in. The whole package is in and it's there and the court has it. And he says Attorney Seligson is ordered to email and then gives an email address to the Plymouth Superior Court before 10 a.m. tomorrow. Word documents of the versions of Ms. Reed's special motions to dismiss dated June 18th and June 23. Okay, so Karen Reed has made 2 anti-SLAPP motions filed on June 18th and June 23rd, but they want Word versions. The problem with the Word versions is if you have a Mac and you don't have Word, you can't open them, I think, right? Remember we saw some ones that were like all like in like code, like they were all like we needed some sort of key to figure them out because they came in all fakakta, remember? And an affidavit setting forth if there was any written or oral response to the June 25th, 2026, 1:43 p.m. and June 26th, 12:31 p.m. emails from Attorney Murphy to Attorney Rosenberg, Seligson, and Waters. If there were, a copy of any written response shall be attached to the affidavit and any oral response should be summarized in the affidavit. Oh, he wants more information. So I guess Aidan Kearney's papers were okay. He just wants Ms. Reed's papers in Word form. Why not PDF? I don't know. Isn't it better for everyone if it's PDF? So tomorrow, if they get approved and they come on the docket, that's what we're doing tomorrow. So we got that going for us. All this stuff happening on the 14th is really not good for me. I'm having a colonoscopy that day, but hopefully I'll be out of anesthesia and able to recap it with you in the afternoon because that morning is the day of the anti-SLAPP hearing so far still at 10 a.m. Federal one doesn't matter because it's not going to be televised, but like you got to get your colonoscopy, everyone. Got to get your colonoscopy. All right. What are you going to do? You got to do it when they say you got to do it. Dun, dun, dun. You want to look at the Emmy nominations? Because I do. So I don't care. It's up to me. And I say yes. Let's look. Because they were just announced this morning by a really, really, really tall guy and a really, really short girl. And it looked really, really funny to me. I was like, whose idea was it to put these 2 people on the stage together? And it looked really weird. All right. Mariska Hargitay, my queen, is going to be the host of the Emmys, which are going to air on September 14th at 8 p.m. Oh my God. Look at her. She's a queen. She's a queen. She's a queen. All right. Here are the nominations. I'm gonna read them in my own voice. Here are the nominations for Outstanding Drama Series. The Diplomat. I haven't watched The Diplomat. Has anyone? The Gilded Age. I do like The Gilded Age, but I just can't stand Cynthia Nixon in that role. Don't ask me why. I don't know why. I just can't stand it. A Knight of the Seven Kingdoms. I have no idea what that is. Paradise. The Pit. You know, I love The Pit. Pluribus. Love Pluribus. Slow Horses. Your Friends and Neighbors. Okay. I love Your Friends and Neighbors. I love Pluribus. I love The Pit. Gilded Age. I don't think it should win. Tell me if you've watched The Diplomat, if you like it. Paradise. I don't even know what that is. Should I watch it? Slow Horses. Don't even know what that is. So tell me, Diplomat is so good. Reminds me of The West Wing. Okay. Is it Aaron Sorkin? What is Paradise? What is Paradise? To me, it sounds like a reality show, like Love Island. Like, isn't the Love Island finale? My kids, all of them are so invested in Love Island. I don't even know what to tell you. I don't know why. I don't know when it became this phenomenon. It's on like every single night and they all fight with each other. Get off Peacock. Who's on Peacock? Get off Peacock. It's crazy. So Red Lips loves The Diplomat and Slow Horses. Knight of the Seven Kingdoms. What is that about? Paradise of Sterling K. Brown. Okay. Okay. Is it on a random channel that I don't have? Maybe that's what it is. I've never met Dave Matthews, but I would love to. All right. Maybe we could have our own like Emmys party and we can all vote. I want to go watch the rest of these though now. See, that's what I do. When the Emmys come out, the noms come out, then I go watch all the things that are nominated so that I can make an educated vote on who I think I should win. Your Friends and Neighbors, I love. I don't know if it's like the best drama of the year, but I think The Pit is really amazing. But again, in all fairness, I got to go watch the rest. Okay. Next. Oh, there's Elle Fanning and Margot's Got Money Troubles, which I did finish because you guys told me I had to finish because I kind of lost interest by the second to last episode. Outstanding Comedy Series. Abbott Elementary. Never seen one episode of it. I just have no interest in it. I don't know why. The Bear, which I think The Bear, I mean, I think I got lost in The Bear after season 2. I was just like, it's not good anymore. Hacks. I love Hacks. I got to catch up. Margot's Got Money Troubles. It was good. It was the Outstanding Comedy Series of the year. I don't think so. Nobody Wants This. I think I watched a couple of episodes of that. Is that the girl who falls in love with the rabbi? Is that the one? Only Murders in the Building. Lost interest after season 1. Shrinking. That's good. Jason Segel and Widow's Bay, which I can't get through episode 1 as Widow's Bay. Has anybody stuck with Widow's Bay? I mean, for my money, Hacks has to win again. They win every time, and they should. The writing on Hacks is phenomenal. Tucker's mom says The Bear did lose it after season 2. Everyone says the Diplomat is amazing. Is it Kerry Russell? Hold on, let me go to Pro and look it up. Is it Kerry Russell? Because I do like Kerry Russell. I feel like she always does those kind of like spy shows. Okay, The Diplomat is on Netflix, and it is with Kerry Russell. That's right. Hulu is on, Paradise is on Hulu. All right. People loved Widow's Bay, yeah? Abbott Elementary is so funny. All right. Only Murders in the Building was really good. Diplomat reminded me of Designated Survivor, but Designated Survivor was 10 times better. You know what I really like is The Hunting Party. I can't believe they canceled it. I'm kind of mad about it. Well, these series. It says extra cheese. Crispy Pep in a Jerry Seinfeld voice. All right, moving on. Outstanding limited or anthology series. All Her Fault. I watched it. I thought it was great. The Beast in Me. I watched that too. I thought it was great. Beef. Didn't see that. DTF St. Louis. I got to be honest. I watched it on the plane the first episode and I was like, this is just weird. And I never went back, but a lot of people say it's really good. And I do love Jason Bateman. Maybe I'll give it another shot. Love Story, John F. Kennedy and Carolyn Bessette. Again, I watched episode 1 and I just never went back. That reminds me of things that I need to go back and watch. Tell me if you watched any of those, if you liked them. And if you're on the replay, tell me what you liked in the comments. Because I'm in the market right now for something else to watch because I can't watch YouTube all day long. I just can't. There's too much drama. And so I do my shows with you. And then I go and I watch other stuff. Right now I'm invested in Outlander. Beef was awesome. Oh, okay. Wait. The Beast in Me and All Her Fault, both really good. I do have Prime. I have everything, please. I got it all. All right, moving on. Outstanding lead actress in a drama series. Carrie Coon for The Gilded Age. She plays, Bertha. I think her name's Bertha, right? Chase Infinity for The Testaments. I loved The Testaments. That's the prequel to The Handmaid's Tale. And there's the ducky right above me. Kerry Russell for The Diplomat. Ray Seahorn for Pluribus, and Zendaya for Euphoria. I don't watch Euphoria. I think that's more of like a kids show, right? Chase Infinity was amazing in The Testaments, but I don't know. Ray Seahorn for Pluribus. Every single scene she was by herself, pretty much. She that's a really hard thing to do. So I don't know. Tell me what you think. Paradise with Sterling K. Brown pictured was among the nominated shows. Disney. Okay. All right. Outstanding lead actor in a drama series. Sterling K. Brown for Paradise. Gary Oldman, Slow Horses. Mark Ruffalo, Task. Rufus Sewell, The Diplomat. Noah Wiley, The Pit. I gotta be honest. I love The Pit, right? I feel like in season 2, Noah Wiley was just whiny the whole time. He was so whiny. So forget it. No, I can't let him have it. Cannot let him have it. And the rest of these shows I haven't watched, so I have to watch them now. Okay? Moving on. Outlander, I just watched. I'm on season 1 only. I just watched The Wedding. That's what I watched last night was The Wedding. And then I think what happens a little bit after the wedding. And so I'm really, really like at the beginning of it. Euphoria started as a teen, but now it's so not for kids. Oh, interesting. Next. Allison Janney received her 15th Emmy nomination for The Diplomat. Looks good in that picture. Outstanding supporting actress in a drama series. Taylor Dearden for The Pit. Yes, Dr. Mel. She's Dr. Mel on The Pit, and she's also the daughter of Bryan Cranston. Interesting, right? Fiona Dourif, The Pit. Oh, man, now I got to look that up. Allison Janney for The Diplomat. Catherine Lanasa for The Pit. Yeah, she's Nurse Dana. That I know. Sapita Mawafi, The Pit. Julianne Nicholson, Paradise. Carolina Widra for Pluribus. I mean, I like Carolina Widra, but I feel like she didn't have a big enough role. Like she wasn't in every single episode. But I mean, of all the Pit nominees, I mean, Catherine Lanasa, I think she took it last year, but she's amazing. But Taylor Dearden was really good too. All right, moving on. Fiona is the dark-haired one who's always sighing. Outstanding supporting actor in a drama series. Patrick Ball for The Pit. Yeah, that's Dr. Langdon, the one who's too good looking with all the dimples and the chin dimples. Billy Crudup for The Morning Show. I love The Morning Show. It's one of my favorites ever. And I have a funny story about Billy Crudup from when I was growing up. My sister and they used to have 4th of July races at our neighborhood beach every 4th of July when we were growing up. And Billy Crudup and his brother used to be in the wheelbarrow races or the 3-legged races or whatever my sister and I were in. And I don't remember it, but she does. She says they cheated. Shauna Tosi, The Pit. Garen Howell, The Pit. Jack Lowden, Slow Horses. Tom Pelfrey, Task. I like Tom Pelfrey. What was he? Wasn't he in Ozark? Carlos Manuel Vesca, Pluribus. That I'm going to have to think about. Because Billy Crudup, wasn't this the season with his mom and the... Yeah, I'm going to think about that a little bit. You should think about it too. And look at, here's Jean Smart. Oh my God, I love Jean Smart so much. Jean Smart, pictured in Hacks, got a nomination. She's been nominated a million times for that show, and she deserves every single one. Outstanding lead actress in a comedy series, Quinta Brunson for Abbott Elementary. She gets nominated every year. Io Adibari for The Bear. Elle Fanning, Margot's Got Money Troubles. That's a new one because that show is new. Lisa Kudrow for The Comeback, which I love because I think The Comeback has come back like every 10 years. Like these comeback seasons are like 10 years apart. And I love Lisa Kudrow. And she recently did an interview. It's on YouTube. You can find it with Jennifer Aniston. Like they did like a whole podcast. So good. It was like actors on actors. And it was Lisa Kudrow and Jennifer Aniston. It was such a nice talk that they had. Jean Smart for Hacks. Jean Smart always wins. She deserves it. Elle Fanning was good. Elle Fanning was good. Michelle Pfeiffer was good in that too. All right, who's this? This is the Matthew Rhys in Widow's Bay. Wasn't Matthew Rhys in another one too? The Beast in Me? He was. All right, outstanding lead actor in a comedy series. Yahya Abdul-Mateen II for Wonder Man. I've never heard of Wonder Man. Steve Carell, Rooster. Again, I tried Rooster one episode and never went back. I was like, Matthew Rhys, Widow's Bay. I mean, I thought he was really good in The Beast in Me, but he's having a year. Jason Segel, Shrinking. Martin Short, Only Murders in the Building. Moving on. I mean, I haven't seen it. I haven't watched any of those shows this season, so I can't comment on that, but you guys can tell me what you think. Oh, and here, Michelle Pfeiffer was nominated. Oh, yes, Queen. There she is in Margot's Got Money Troubles, which was a very different role for her than the Madison. Maybe she wasn't eligible for the Madison because maybe that came out this year. Outstanding supporting actress in a comedy series. Dale Dickey, Widow's Bay. Hannah Einbinder for Hacks. Love Hannah Einbinder, by the way, is the daughter of Lorraine Newman, who's one of the original SNL cast members. Remember Lorraine Newman? Back when it was John Belushi, Dan Aykroyd, Gilda Radner. Hannah Einbinder is her daughter. Janelle James for Abbott Elementary. Kate O'Flynn, Widow's Bay. Michelle Pfeiffer, Margot's Got Money Troubles. Margot's Got Money Troubles. Outstanding supporting actor in a comedy series. Coleman Domingo, The Four Seasons. I don't know what that is. Paul Downs for Hacks. I love him. I love him so much. He's the agent of both Hannah Einbinder's character and Jean Smart's. Harrison Ford for Shrinking. Nick Offerman, Margot's Got Money Troubles. Oh yeah, he plays the father, the wrestler. What's his name again? Jinx. Stephen Root, Widow's Bay. Michael Urie for Shrinking. I'd like 4 seasons. I'll look for it. Thank you. Tyler James Williams, Abbott Elementary. The great thing about Paul Downs is also, I think he's the writer and producer of Hacks, and his wife, I think it's his wife, who also is his co-writer. I think her name is Lucia Aniello, as I recall. And I also think, wait until we get to it, but here's Sarah Pigeon. She played Carolyn Bessette. She was nominated, so that's nice. I got to go back and finish that. Outstanding lead actress in a limited or anthology series or movie. Claire Danes, The Beast in Me. She was really good. Really good. Sally Fields, Remarkably Bright Creatures. Carey Mulligan for Beef. Sarah Pigeon, Love Story. JFK and Carolyn Bessette. Sarah Snook, All Her Fault. She was good. This is my favorite. Wait, Wyatt? This is in the wrong category. Megan Stalter for Hacks. No, that's not. She's not in the right category. I think she was nominated for supporting actress in a comedy series. This is outstanding lead actress in a limited series. They did it wrong. Megan Stalter for Hacks is amazing. She's hilarious. I love her so much. I started following her when she had like no followers, and she's blown up, and I love it for her. Jessica Williams for Shrinking. But also Shrinking is not a limited series. All right, they screwed something up here. Outstanding lead actor in a limited or anthology series or movie. Riz Ahmed for Bait. I don't know what Bait is. Jason Bateman, Black Rabbit. Oh, so good. So good in that. Black Rabbit is amazing. If you haven't seen it, I loved it. Charlie Hunnam, Monster, the Ed Gein story. Oscar Isaac for Beef. Matthew Reese for The Beast and Me. Oh, Matthew Reese got 2 noms, I guess. The Beast and Me and Widow's Bay. Good for, wow, that's a double nominee. Sarah Snook and Dakota Fanning got nominated for All Her Fault. Yeah, Dakota Fanning was really good in that. Everyone hit the like button. Outstanding supporting actress in a limited anthology series or movie. Linda Cardellini for DTF St. Louis. She's in everything now. Ever since she was in that other show, which I can't think of the name of right now, she's been in everything. DTF St. Louis, Dakota Fanning, All Her Fault. Laurie Metcalf, Monster, the Ed Gein story. Joy Sunday, DTF St. Louis. Yoon Yu Young for Beef. Constance Zimmer, Love Story. JFK Jr. and Carolyn Bessette. Multiple DTF St. Louis stars, Jason Bateman and David Harbour, pictured above, got nominated. Outstanding supporting actor in a limited or anthology series or movie, Jason Bateman, DTF St. Louis. Richard Gadd, Half Man. I don't know what Half Man is. David Harbour, DTF St. Louis. Richard Jenkins, DTF St. Louis. Charles Melton, Beef. Nick Offerman, Death by Lightning. I haven't watched any of them, so I can't comment. And then they have the guest actors. And then they have the guest actors in drama series, comedies. I'll put them up here. 1, 2, 3, 4, 5. 5 guest actresses got nominated for their roles in Hacks. All right, so tell me what I should watch. Maybe you can all get some good ideas of what to watch. And then it gets into reality shows, variety series. SNL usually wins, right? Outstanding movie. Well, it must be movie made for television. Heads of State, Miss You, Love You, People We Meet on Vacation, Remarkably Bright Creatures, Tom Clancy's Jack Ryan, Ghost Wars. And then it goes on with variety specials, blah, 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 blah. All right, thoughts, questions, comments, concerns. People, you can tell people are behind because they're like, timing is suspicious. Timing is suspicious. Happy hump day to you, Mimi. Just watch Microdot's new video, The Catastrophe. His focus is the Sandra Birchmore case, and it's done brilliantly. Excellent. I got his hat on today. So that's a great segue into telling all of you to get on over there and watch Microdot's new video on Sandra Birchmore. That's fantastic. Thank you for telling me because I haven't seen it yet. Deanna, thank you so much. So sorry. B was watching something else on his TV, and I thought your chat was on my iPhone. I don't know what that means. The Goodmans are here, except Brian's cheating on me, and he's watching someone else right now. And you've been watching The Bear, and you like it? Thank you. Appreciate you, Goodmans. All right. Tomorrow, I guess we're going to come back. I'm going to wait for the motion to papers to drop, though, so it's probably going to be afternoon or whenever it happens. So you're going to want to make sure that you're subscribed and make sure you have all your notifications set. Make sure, that you do all the things. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet. Try and stay sane. Thank the moderators. Tip your servers. I'll be here all week. I don't know. It's already Wednesday. And thank you for hanging out with me for almost 4 hours today. My list to you is obviously Outlander. I heard From was really good too. I did hear that, Lily Lime. Upload, Good Omens, Ghosts, Grace and Frankie, Young Sherlock, Spider Noir, Scarpetta. I watched Scarpetta. I did like that a lot. 56 Days and Reacher for Prime. All right. The only ones I've watched on there. Scarpetta. Like and subscribe. Do all the things that YouTube likes. And I'm going to see you guys tomorrow. But I don't know when. That's why you need your notification set. Go on over and watch Microdots. I love you guys. I'm going to see you real soon. Peace out.